Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives in New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and welcome to the 4th of July holiday weekend. For those of you in the U.S. who celebrate tomorrow's 4th of July, a lot of people have off tomorrow, a lot of people don't. Patriotic, reminding us that justice is coming. We hope so. How's everybody doing today? Prosecute. The female on the cover shot, the thumbnail is Ana Walshe, the deceased. The wife, well, we don't know if she's deceased because her body's never been found. We'll do a little summary before we get into the papers, because there's a lot of papers. And we watched the hearing the other day on the motion to suppress, but we didn't look at yet the Commonwealth's opposition to the motion to suppress. And, might shock you, it might surprise you on what their arguments are on why it's no big whoop that they didn't have a search warrant to go through Brian Walsh's phones because he consented, but they went outside the scope of the consent, and they based all of their subsequent search warrants on the Google searches, which was outside the scope of the consent that they had. But, look the other way. No big whoop. Bukhenik, Fanning, Tully, Proctor, all of them are involved. It's a Norfolk County case. And Malta is in the chat. Hello, legend provocateur. There's a YouTube user here who doesn't have a name who says, what Broadway show did you happen to go see? And did you enjoy it? I love to go to Broadway to see musicals, but nothing really jumps out to see lately. We saw the matinee of a new show that was nominated for a lot of Tonys called Oh, Mary. It's a satirical comedy about Mary Todd Lincoln, and it was hilarious. We really loved it. And then because we were already there and we were able to get half-price tickets, we went to see the 7 o'clock showing of Chicago, which I will see a million times in a row. I don't care. And that's my favorite, like TikTok. Oh, yes, oh, yes, oh, yes. It's from Chicago. So it was a fun city day. And, nothing like going to 2 Broadway shows in one day, right? If you're already there, you're already there. You're already in the city. Thank you. I'm on. I can't lie. This feels weird for your super sticker. And Jessica is from the UK, and her birthday is the 4th of July. Happy birthday, Jessica. Happy birthday. No, not about the traveling Mary. It's not. It's about Mary Todd Lincoln, and it was funny. Oh, are you going in a couple of weeks, Holly? Yeah, it was good. The understudy performed yesterday. It's supposed to be Titus Burgess is in it now, but the understudy performed, and she was amazing. So it was really good. They're doing a new thing now where if there's an understudy, they let you know ahead of time and you can rebook your tickets. But I feel so badly for the understudy if a lot of people cancel. She was amazing and good for her getting her time up there on the stage. I love it. Too much going on yesterday between Diddy and Koberger. I was on the train. I watched some of the coverage. I was just like, I can't even handle it was like overload. Couldn't handle it. It was too much for one day. Enough. Horrifying all around, horrifying. And so I decided we're going to come back and talk about Brian Walshe again today. And we're going to talk about Massachusetts, where your constitutional rights go to die. Maybe some people might think, perhaps. But before we do that, let's take a quick look at, if I have it here. Hang on. One moment. While we give some people a chance to come in. The Fourth Amendment. Let's take a look at the Fourth Amendment. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Guess who wrote the probable cause affidavits on the warrants for Brian Walshe? Yep, Michael Proctor. Michael Proctor did. They're not going to call him to testify, the Commonwealth. Norfolk County DA's office is not going to call Michael Proctor to testify because, you know, he's now been dishonorably discharged and stuff. So there's that. For those of you who are not familiar with the Brian Walshe case, it was proctored. It was all proctored. Thanks, Gen X 1968. Ana Walshe is when she went missing, a 39-year-old mother of three, ages 2, 4, and 6. Cohasset family, Massachusetts. Married to a guy named Brian Walshe. I think he was 47 at the time this happened. New Year's Day, 2023. Ana Walshe went missing. She was reported missing by her boss in Washington, D.C. She split her time between Washington, D.C. and Cohasset. Her husband, Brian, had been convicted of selling fake Andy Warhol paintings on eBay. I don't know if at the time he had been convicted. But he was like a con man, okay, for lack of a better term. He went after his father's estate. He's got a bad reputation. I don't know if he's a killer, and I don't know if we're ever going to find out if he's a killer because the MSP screwed up so badly on these searches and seizures of his devices. And you may have heard about the horrifying Google searches that he made, which apparently I'm not allowed to talk about on YouTube because the stream that I did 2 streams ago, where I put the Google searches up on the screen, was completely demonetized for being unfriendly to advertisers. And yet so many comments that I got in the comments were like, why are there so many I guess people who don't have YouTube Premium are like, why there's ads every 3 minutes? Apparently YouTube doesn't want you to know about this case. Norfolk County DA's office definitely doesn't want you to know about this case. And this case was taken away from Judge Cannone and transferred to Judge Diane Freniere, who you may remember her. She was the judge who tried the Christine Ritchie case. Christine Ritchie was a woman who stabbed her firefighter husband to death, and she was convicted and sentenced to life with, I think, possibility of parole, 20 years. So if you watched that trial, that you would know this judge, and they're bringing her in from Middlesex to Norfolk County, although the hearings have been held in Middlesex on Brian Walshe. So I don't know why. I can't explain it to you because I have no idea why they're doing it that way. Brian Walshe is accused of killing and dismembering his wife on New Year's Day of 2023. Her body's never been found. Oh, Leanne, demonetized means that they do not give creators ad revenue because they claim it's unfriendly to advertisers, and yet they continue to show ads on your channel anyway. So I think it's a scam, but I guess graphic content. It happened also during the Karen Reed trial whenever they would show pictures of the arm on the screen, which is why I kept taking the arm pictures down, or I wouldn't show them. But this is just, Google searches that we talked about and described. They never found her. How do they know? That's a great question. She also had dual citizenship with Serbia, and she was having an affair. So there's a lot of questions. I don't know why they took it away from Judge Cannone. They took away all of her criminal cases except for Karen Reed. Whatever, clever. And they specially assigned her to continue the retrial of Karen Reed. Thanks for that. I like that. So, yeah, they keep all the money. That's what they do. They keep all the money. But they show ads anyway. So it's like a scam. That's what they do. So what I want to do first, since we've been talking about and we watched the hearing to suppress, apparently the hearing was 3 days. I could only find some of it streamed on YouTube by Law and Crime Trials. The rest of it, I don't know where it is. But apparently there were 3 days of hearings, May 19th, May 20th, and June 18th of 2025. And we did not get to hear any argument. So we need to go back to the papers to determine what the arguments are, and it has not yet been ruled upon. So we'll see. I don't know about that. Defense Diaries edit the live stream before they post it on their channel, but I've seen them go live before 1,000,000 times. So I don't know about that. I don't know. I go back and blur it sometimes. I don't know. I don't know. I don't know. Yeah, I don't know where the McCabe and Albert interviews disappeared to. I think that they, I think you can still find them if you look hard. I think that I also did run them on my channel. So if you go back to one of my live streams where we talked about it, you can see them there. I don't know. This is what they do. They chat. And so it's not the demonetization that I care about, but your video gets shadow banned. So it doesn't get pushed out to as many people. So technically, like, nobody gets to really see it. And it's insane. Greg says MSP has been doing this crap for so long, it's SOP, standard operating procedure. And he can see all the way from Australia that that's what's happening here. I think so too. I think they cut corners, and the travesty is going to be if that Brian Walshe actually did take the life of his wife, Ana, and all of this evidence is suppressed because if Judge Diane Freniere thinks the Constitution is important and they cut corners and they illegally searched his devices, everything stemming from that is fruit of the poisonous tree. And if none of that stuff is allowed in, they don't have a whole hell of a lot, because the video surveillance that they got of him at Home Depot and other places wouldn't come in either, because they got his location data from his phone, but they weren't supposed to get it from his phone until they had a warrant. But they didn't have a warrant because, Proctor, Bukhenik, Guarino, and Fanning and Tully were all involved. See what happens? Right? So it's a lot of papers. It's going to be a reading stream pretty much, but I think we need to look at them together, because you need to understand what the Commonwealth is arguing and why they think that they should be allowed to do this, because your constitutional rights are at issue, as always, if you live in the state of Massachusetts, and it needs to be exposed. It needs to be exposed, because Karen Reed's not the only one. She's not the only one. Except in that case, John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. In this case, Brian Walshe may have actually done it, but because of the illegal searches that they did on his devices, if that evidence is suppressed, they don't have a whole hell of a lot of evidence. And he's got little children, and this is tragic. He's being held in Norfolk County, Pokey, since 2023. Okay? Everyone hit the like button on your way in, because that is a nice thing to do. Acknowledge the stream. Joe Pa says, my heaven is a nice house in the sky. I got central heating, and I'm all right. That's it. I'll always accept a Dave Matthews quote at any time of day. They're always appropriate, and they're always here. All right. This is the Commonwealth's preliminary opposition to motion to suppress results of consent search of iPhone and iPads. And this was filed on May 9th of 2025, and we were neck deep in Karen Reed, and so we didn't cover it then, but we're going to cover it now because here we go. The Commonwealth asked this court to deny the defendant's motion to suppress information received from his electronic devices, iPhone 13 mini, 6-year-old son's iPad mini 6, and iPad 6 with cracked screen, as those devices searched with his consent, and the search did not exceed the scope of his consent. And for those of you who are not familiar with the case, here is a summary factual background. Ana Walshe is reported to be missing. Footnote number 2. Well, footnote number 1 says the Commonwealth reserves the right to request the opportunity to submit a supplemental memorandum after the evidentiary hearing, which they did. And I have a copy of that as well. And then footnote 2 says this summary includes information that the Commonwealth expects to elicit at the evidentiary hearing from witness testimony, reports, transcripts, and audio recordings of interviews, search warrants, and other materials. The Commonwealth anticipates 6 witnesses at the evidentiary hearing. 5 are available on May 19th and 20th. The Commonwealth's last witness is not available on May 19th, but is available on May 20th. And then, as I said, they had a third date on June 18th, which sometime after that, Law and Crime put everything up on one video, but you'll see that there's some witnesses that we didn't get to hear. Ana Walshe was employed at Tishman Speyer in Washington, D.C. Footnote 3, and it says because she shares a surname with the defendant, Ana is referred to by her first name. On Friday, December 30th, 2022, having been in D.C. for work, Ana arrived at her family's residence at 516 Chief Justice Cushing Highway, Cohasset, to spend time with her husband and 3 young children, ages 6, 4, and 2. On Wednesday, January 4th, 2023, the defendant contacted Ana's employer to report that he last saw Ana on the morning of Sunday, January 1st of 2023, when she left to return to D.C. Hugh Dunleavy, the head of security for Tishman Speyer, asked if he had called police. The defendant said he did not know which department to call. Dunleavy told him to call Cohasset police, but the defendant never did. That same day, Dunleavy contacted Cohasset police and requested a well-being check for Ana. Cohasset officer Gregory Lawrence, we saw his testimony in one of the last, I think, 2 streams ago, went to the 516 Chief Justice Cushing Highway residence at 11:44 a.m. The defendant said that Ana used a rideshare service when she departed for Logan Airport on January 1st of 2023 between 6 and 7 a.m. Ana was entered into NCIC as a missing person that day. Footnote 4, National Crime Information Center. Recorded interview number 1 on January 4th of 2023. Okay, so here's an interesting tidbit, is that all of Brian Walshe's interviews were actually recorded by body cam, by Cohasset PD and the MSP, because they do know how to do that. They just didn't do it in the murder investigation of John O'Keefe. Put a pin in that. And then footnote number 4 says, number 5, the interviews have been transcribed by Cambridge Transcriptions. References here are to transcript of the first interview, January 4th, 2023, as 1 or Roman 1. The second interview on January 5th of 2023 as Roman 2. The third interview on January 7th, 2023 as Roman 3. And the fourth interview on January 8th, 2023 as Roman 4, followed by page. The Commonwealth submits the audio recordings and transcripts in conjunction with this opposition and intends to present testimony from officers who were present for the interviews and admit them into evidence. So during this first interview on January 4th with Sergeant Harrison Schmidt and Officer Lawrence, wait, I skipped ahead. Sorry, wait, hang on. The defendant participated in 4 audio recorded interviews with the police on January 4th, 5th, 7th, and 8th, 2023. Tracy Miner, the attorney who represented him in a federal criminal proceeding, was present for the January 7 and 8 interviews. Recorded interview number 1. January 4th of 2023. At 6:35 p.m. on January 4th, Cohasset Detective Sergeant Harrison Schmidt and Officer Lawrence returned to the Cohasset residence. The 47-year-old defendant was calm and cooperative as he relayed the following. Ana worked in D.C., flew to Boston on JetBlue, and landed around 8 a.m. on Friday, December 30th of 2022. He showed officers a screenshot of Ana's travel details on his phone and said that Ana used his phone to send herself pictures. Footnote 6. And then footnote 6 says, the defendant encouraged Detective Sergeant Schmidt to look at his phone. Please look at it. Anything that's going to help you. Please look at anything. She sent me some videos of her that day with the sun. Then you'll get to the area where I start texting her and she doesn't return to me. And if you want to look further, there's probably a year's worth of text there. If anything that is supportive, please. Toward the end of the interview, Detective Sergeant Schmidt asked to look at photos on the camera roll. The defendant, quote, you can take a look. There's probably 1,000 photos, end quote. Given back the phone, the defendant said, quote, anytime you want to go through this, feel free. It's so weird. Like my whole life is like on this thing. I can be like, here's my life. Go enjoy it, end quote. They're going to argue that he gave verbal consent that they could look at whatever they want on his phone, despite the written agreement between Norfolk County Assistant District Attorney Lynn Beland and his attorney. When Ana's SIM card died the week before, she had called the defendant on Viber, an app that she had used to communicate from Europe. We were wondering what Viber was one day, remember? That's what it is. It's like WhatsApp. It's just called Viber. While their younger 2 children attended kindercare, Ana spent December 30th with their 6-year-old son. On Saturday, December 31st, 2022, Ana went to a gym and a nail salon. Ana took the children to an indoor play space while the defendant prepared New Year's Eve dinner. Ana's former boss was their guest on New Year's Eve, arriving around 8 p.m. and departing around 1 a.m. and then said that she needed to return to D.C. for work the next morning, and they went to bed around 1:30 a.m. Ana had been scheduled to return to D.C. on Tuesday, January 3rd of 2023, but the defendant said that a work emergency required her to leave on Sunday, January 1st of 2023 around 6 a.m. Carrying a Louis Vuitton travel bag, she kissed their 6-year-old son goodbye and got into a taxi. See, it says taxi, according to his interview, taxi. The defendant said that Ana's iMessages were appearing on his phone and that his phone had been mislaid until Monday, January 2nd of 2023. He said that he had emailed Ana but had not heard from her. Not wanting to embarrass her, he waited until Wednesday, January 4th to contact her employer. Footnote 7. The defendant explained that Ana had been scheduled to come home on December 25th of 2022. He was upset when he could not reach her, and because her flight had been canceled, she drove to Cohasset and arrived around 8 p.m. on December 25th, 2022, which, as you know, Christmas Day. He couldn't get a hold of her. Turns out that we're going to find out later that she was having an affair. I don't know if he knew or not, because he said in his statements to these police officers that he wasn't aware of any affair. He said Ana usually had her phone with her, but it ran out of power at times. It was rare for them not to be in contact. I also think it was odd. I have a question for you guys in the chat. Maybe if anybody knows that her SIM card died. Does your SIM card ever die? Especially if you use your phone constantly for business? Does your phone? I don't know. Don't know. He explained that Ana worked in D.C. because of the higher salary, which helped them financially. He could not join Ana in D.C. because he had legal issues, owed restitution, and was locked down because, quote, I misrepresented a Warhol piece. You can read all about it in the papers, end quote. The defendant offered to provide his attorney's number and said, I didn't want to hide anything from you because if that could lead to finding my wife sooner, that's the most important thing. Police discussed Ana's passport, health, relatives, substance use, and memory. The defendant described what Ana wore and the bags she had when she left. Police asked to look at the camera roll of his phone. When Detective Sergeant Schmidt handed the phone back, the defendant said, "And anytime you want to go through this, feel free." After the recorded interview ended, police searched around the home with the defendant's consent, including the pool shed, yard, and the defendant's Volvo SUV, which had a disposable plastic liner in the rear cargo area. On January 5th of 2023, Cohasset police continued looking for Ana and sought assistance from the Massachusetts State Police. Troopers from the State Police Detective Unit, attached to the Norfolk District Attorney's Office, joined the search for Ana and established a command post with Cohasset Police. Guess who? Recorded interview number 2 on January 5th of 2023. Weirdly enough, the command post was, I think, behind a Stop and Shop in, I don't know if it was Cohasset or a nearby town. SIM cards do go bad, says Gator Girl. I've had 2 replaced in the past. All right, thank you. All right. The Vovo, right? They called it a Vovo on the stand. Who was testifying kept saying Vovo. Recorded interview number 2, January 5th, 2023. MSP Trooper David DeCicco and Sergeant Schmidt, Detective Sergeant Schmidt, interviewed the defendant at his residence beginning at 7:56 p.m. Footnote 10. Well, footnote 9 says Trooper DeCicco has been promoted to sergeant. Remember Trooper DeCicco, who said to Proctor, "Rookie move, you should have had me and Jeff do it," when Proctor was complaining that the whack job ME, Irene Scordi-Bello, wouldn't change the manner of death on John O'Keefe's death certificate from undetermined to homicide. DeCicco said, "Rookie move, you should have had me and Jeff do it." Footnote 10 says, while the defendant was being interviewed, MSP Sergeant Yuri Bukhenik and Cohasset Detective Lieutenant Michael Lopes were also at the house and spoke with the defendant's mother and 6-year-old son. The defendant's 6-year-old son said that his iPad had stopped working on the morning of January 1st of 2023, and his mother, Ana, fixed it before she left. We went a little nutso when Bukhenik said on the stand that he interviewed the 6-year-old, because, you know, there are special people for that. And he also testified at the hearing, and I don't know if they're going to bring it up in these papers. Bukhenik also testified that the 6-year-old son told him that his mother, he went downstairs and his mother was on the couch laying under his blanket in her pajamas, that she went upstairs and got changed into her street clothes. She came downstairs carrying a 2-foot-long duffel bag, fixed his iPad, and then left to get in a cab. I don't know if they're going to say that in these papers, but that's what Bukhenik testified to. The defendant said that Ana was up early and kissed him goodbye at 6 a.m. before she said goodbye to their 6-year-old son, who was already awake. He described what he thought Ana was likely wearing and the bags she carried. He had not seen Ana leave. He got up and made breakfast for the children around 7 a.m. When Robin, the nanny, arrived at 2 p.m., he went to Shaw's for groceries and went to Swampscott to see his mother around 4 p.m. He said he went to Whole Foods and CVS on the North Shore before returning home. Yuri still is with MS. Oh, why is he? Why is he? I don't know. This could be his downfall. We'll see. We'll see. When asked if Ana had ever been missing before, the defendant explained that she had been late for Christmas because she had missed her flight. I thought we just read a few minutes ago that it was canceled. He explained that he did not have his phone until his son found it in a bed, so waited until Wednesday to call people, and said he probably should have started earlier. When he found his phone, he called Ana on Monday around 2:30 or 3:30 p.m. and left a message. "You can call. It's been a while. You've had some rest. I don't know what's going on." End quote. Yeah, 07 Enigma says every case they have worked on is tainted. Who knows what is true? They should be called the taint team, these guys, because everything they touch, yikes. SIM cards can go bad, says Rebecca. I don't know why ads on replay have become so frequent recently. I don't know. YouTube keeps changing everything without asking my permission. For example, this top fans thing with the crowns, I thought I turned it off. I don't know why it's there. I don't like it. They did turn it off, so I don't know why it's still showing up. I don't like it. And also, they're showing ads on my stream, even though they said it's not friendly to advertisers. So explain that to me, because the Google searches here are too graphic, apparently. A lot of women, oh, you're very welcome, Fearless Query 21. A lot of people have told me that in Cohasset, where they lived, and the driveway is very long, and it's kind of, I don't know if it's a remote area. I don't know if it's multiple acre zoning. I'm not sure, but it's hard to get an Uber and a Lyft. And so most people take car service, which also could be possible. And we'll see that when we get to the searches, the warrants, or the search warrants that the MSP sent out to Lyft and Uber. You can tell me if you live in Cohasset, if you need to get a Lyft or an Uber, if you have to call a car service or a taxi or a cab. I don't know. The defendant explained that Ana had the job, quote, the job of her dreams, and she had gotten like 2 or 3 times the money that she had been making before. She was worried she was in over her head, end quote. When asked, the defendant said Ana had not talked about suicide, was planning to see a psychiatrist, but had no mental health issues. Other than the distance, there were no issues in their marriage and no extramarital affairs. When Trooper DeChico explained that there are many reasons a person goes missing, including being abused, the defendant denied any violence in their relationship. He said that Ana's mother's illness and medical issues with his mother had caused stress. The defendant stated that he was, wait, where's this? I forgot to finish the last footnote, which talked about the 6-year-old son. It says, during the interview, the defendant's mother, her name's Ana Walshe, voluntarily showed call logs on her phone to Sergeant Bukhenik. One missed call was from a number that was saved in her contacts as the oldest, the 6-year-old son. This phone was later observed to be inside the defendant's Volvo on January 5th of 2023. The defendant stated that he was having difficulty sleeping and thinking, and that his mother had hired an investigative team to find Ana, who did not believe Ana had returned to DC. He said Ana was not the type of person to leave the family, and he had no idea where she was. Oh, coffee nut. I like that. Favorite time of the day is when I get to sit on my couch and watch and listen to you read to us. Also, you know, maybe you're driving, maybe you got like 6-hour drive ahead of you for the holiday weekend. I can keep you company in your car while you drive. Because this is, if these searches get thrown out, I mean, better to see one guilty person walk free than an innocent person incarcerated, right? Because, you know, constitutional rights are a thing. All right, moving on. The defendant provided information about Ana's finances, including a list of her financial institutions and credit cards, and said that everything was in her name because of his legal problems. He said that Ana was regularly in DC and had recently visited Chicago for work and Belgrade, Serbia, to see her mother. Am I pronouncing Belgrade right? Because every town in Massachusetts that I try and pronounce is completely the opposite of what I would think it is. He was unable to contact Ana for part of the time she was in Belgrade. Generally, they were in contact through calls or texts several times a day. The defendant explained that Ana's phone was not on the family's phone plan, as her work paid her cell phone bill. Asked if he had ever had a physical confrontation with Ana, the defendant said, "Please feel free to ask any questions that you have. Don't worry about me being offended. I understand that you're here to find Ana and you're working for her," end quote. Asked if he had hurt his wife, the defendant said, no, sir, I wouldn't hurt my wife. I mean, I love my wife. I mean, all we want is to have her back. This family doesn't work without her, and then we can't function without my wife. Thanks, Bob. I'm going to star that comment for later. I don't know. A lot of people, you know, are questioning why a 6-year-old needs a phone. Maybe because his mom was in DC all the time and she wanted to be able to reach him or have him call her. Or sometimes kids have phones for watching videos and other things, not necessarily calling people. So it's not that unusual, believe it or not. But a lot of people seem to have, you know, think that it is unusual. And I don't think that, Belgrade is correct. Thank you. A discussion of police wanting to download the defendant's phone then took place. Okay, so here's what they're also relying on: these conversations that were recorded instead of the written agreement between his attorney and Lynn Beland of Norfolk County DA's office. So here's the conversation between DeChico and Brian Walshe. DeChico: okay, well, I know you said you're willing to, do whatever you can to help the investigation. We thank you for that. And, part of what I think is trying to understand Ana. I think if you would allow us to look through your phone and consent to us downloading your phone and seeing some of the communications between you and her, and like her tone, and I believe you said in your interview that she said she may have used your phone occasionally to, and then Walshe interrupts and says, yeah. And DeChico says, send and receive stuff. And defendant says, yeah. So again, some of the communications between you and her tone. That's the scope of the agreement that is written between Beland and Tracy Miner, his attorney at the time, for his federal problems with selling fake Andy Warhols to an art collector who specialized in Andy Warhols on eBay. You can't make it up. You just can't. Trooper DeChico then says, I think it'll help us really create a permanent timeline of events. Here we go again with timelines and the MSP. Timelines. And it just made me think, as I often do, about these things. Was it really Peggy O'Keefe who told Jennifer McCabe and Kerry Roberts to create a timeline? You'll see as we get into more information on the timeline. Because timelines seem to be something that MSP does to try and clear people. We need a timeline. We need to nail down your timeline. Remember, this is 1 year later, 1 year after the murder of John O'Keefe. Timelines are everywhere. Time drifts. I think DeChico says, I think it'll really help us really create a permanent timeline of events of the first and the 31st and the first, and maybe get a better insight into Ana. Is that something you'd be okay with? Walshe: so just to be clear, you want to download everything on my phone? DeChico: we will download with the extraction. We'll download all the contents of your phone. Yes. Walshe: oh, that's a lot. Detective Schmidt: what we're focusing on, though, is, well, what we're interested in, yes, it downloads everything, but what we're interested in is locating Ana and finding the information specifically in there that would help us do that, the Ana specific content. Walshe: that's a huge amount of personal information, gentlemen. Detective Schmidt: it's a big ask, but there's a lot on the line. Defendant Walshe: no, there is a lot on the line. Detective Schmidt: you know what I mean? Walshe: DeChico: what's your concern? Walshe: I don't know. DeChico: is it your other legal issues? Walshe: that's one of them. I would guess my request would be, I'm willing to do anything, but my only request would be, like, because Tracy Miner called me today about what's going on. Detective Schmidt: who's that? Walshe: Tracy Miner is who's representing me in my other legal issues. Detective Schmidt: okay, yep. Walshe: so she said, before you do anything like this, you have to talk to me. I want to do everything I can to support this 100%, but I got to call her about it. Detective Schmidt: she said, before you do anything, like turn over the phone or anything? Walshe: no, like before you do anything. I mean, because she always wants to be here to talk to law enforcement. And I said, well, I'm just going to talk to them and give them whatever they want, but I just have to ask her quickly about that. I'm sure it'll be fine. Or she might say, can we just do the information that you're asking for? He gets it. The defendant, whose rights may have been violated. Detective Schmidt: right. DeChico: well, that's all we would be interested in. We'd be interested in your communication with Ana and the date of, the 31st and the 1st through the present. We're not interested in your other past and your other issues. Defendant: no, I understand. DeChico: and that being said, I believe, we would, you're represented by counsel in that matter. I don't, I'm not a legal, despite being a police officer, I'm not a legal expert, but talk to your attorney. But I believe that would require a search warrant for that stuff to be used against you, and that's not what we're looking to even go into. Okay. Hello, this is the Commonwealth's papers. Okay. This is the Commonwealth papers. This is the transcript of the conversations DeChico and Schmidt had with him. And they're basically admitting that that's what they agreed to before it was even put in writing. Defendant, how long would it take for you to download it? DeChico, it would take, once we hook it up to the machine, which is in Canton, it would take, depending on how many gigabytes of data it is it a lot? Or defendant, yeah, it's like 128 or something. Detective Schmidt, it's a smaller one. DeChico, then I don't know, it could be 30 minutes, 30 to an hour. Defendant, okay, so an hour of time to Canton. DeChico, yeah, call it an hour to download. I mean, yeah, I think it would be useful to our investigation, and I think it would be, defendant, okay. DeChico, helpful if you would consent to it. Defendant, all right, well, I just want to know you to know that I'm absolutely, that is my intention. DeChico, sure. Defendant, and my only request is to talk to Tracy and let her know that that's what I want to do. At least let her give me what my risk exposure would be in life right now. Detective Schmidt, just so you're aware, if it's any peace of mind, like we don't have a crime, we're not investigating a crime. This is a missing person. Defendant, no, Detective Schmidt, this is a defendant. I understand, Detective Schmidt. We're here out of a community caretaking function. Defendant, no, Detective Schmidt, just so we're abundantly clear, like it's defendant, I'm fully, DeChico, okay. Defendant, no, I'm fully aware of that and I appreciate it. And I want you to know I'm not going to, I'll be very quick with it. And if Tracy and I can talk in the morning, then what would be the process? I would just give you the phone, or I would come to Canton, or I need to be away. I do a lot of work on the phone as well. It's the DeChico, yeah, well, we could come get it and we could actually potentially do it here. Detective Schmidt, yeah. Defendant, oh, okay. Oh, really? Okay. DeChico, we have a portable device. We could, defendant, okay. Yeah, I don't know. What is a community caretaking function, Gaily May? I don't know. Police can always lie to you. They can, except for when you have a written agreement between your attorney and the DA. They got to follow that, right? Because he's not going to hand over his devices until he talks to his attorney and they have it in writing. So yeah, they can. So this is 2023. Somebody said, when is this? There's a extensive show notes below the video. If you need anything, you want to check it. And also there's a link to the playlist on this video. Yes, Magnolia Gypsy. Sure, it's not shocking they're lying to him. It is then lying to a judge after a consent agreement. Correct. Yes. Oh, yes. Oh, yes. And we know that they have portable devices because they did that to Rich Schiffer in the Rubber Ducky Gate case, remember? They went to Rich Schiffer's business, Canton Fence Company. If you need a fence, go to Rich, Canton Fence Company. And they brought and downloaded his text stream data from his Toyota truck, I think it was, right in the parking lot of his business. They've got a mobile forensics team. They can do it, but they didn't. Yeah, we could just do it here and do a download, says DeChico. There's a guy who works in my office that does it really efficiently, and I can send him over. Defendant, okay, great. So will you gentlemen honor my request to give me a moment to talk to Tracy about it? DeChico, well, no one's taking your phone from you. Defendant, no. But I'm only interested in finding Ana. And DeChico, yeah, I don't care what it takes, says Walshe. But I just have to make sure that, that I listen to all the advice I have coming my way, which is a lot. I do apologize, but I most likely will be able to do that. And I'll be able to do it tomorrow. And that is my intention and my declaration. Right. Meanwhile, Karen and Aiden still haven't gotten their phones back, says Olivia Nile. Hi, Olivia. Detective Schmidt. Okay. DeChico, is there any, what possessions do we know that Ana had on her person? Like what's in her wallet? Oh, it sounds like a Capital One commercial. What's in your wallet? By Jennifer Garner. And now they go back to attorney speak. And we're no longer talking about the interview, but Commonwealth says, during the interview, the defendant's 6-year-old son brought officers his artwork, and the defendant repeated that his son saw Ana on January 1st. They kissed and she left in a car at the bottom of the driveway. The defendant told police that Ana had dual citizenship with America and Serbian passports. Trooper DeChico left briefly to speak with the 6-year-old son, then asked the defendant whether he would bring the children for a forensic interview. while with a civilian interviewer, the defendant agreed to do so the next day. Well, we heard during the hearing that it was Bukhenik who interviewed the 6-year-old. I think they're trying to distance him from this too, but he did testify at the evidentiary hearing, which Judge Cannone would never order an evidentiary hearing on, the motion to dismiss, the jury tampering issues, all that stuff. No. This judge, Diane Freniere, she's not having any of it. She runs a tight ship, I think. It's the impression I got so far. The defendant agreed to do a forensic interview the next day. And then footnote 11 says the defendant canceled the interviews. The children were interviewed on January 9th with authorization from the Department of Children and Families. The defendant agreed that the police could look through the house and the attic, which had not been previously searched. The interview ended at 8:53 p.m. The defendant unlocked his Volvo SUV for police who saw a January 4th, 2023 receipt from Lowe's Home Improvement in Weymouth, an iPhone in the center console of the car. The carpet had fresh vacuum marks, and the plastic disposable liner that had been observed the previous day was not present. Detective Sergeant Schmidt asked where that liner was. The defendant pointed to the garbage area. Remember, we heard Sergeant Schmidt testify about that when he was cross-examined, of course, by Larry Tipton, who represented Penny McGee and got her acquitted. Larry Tipton is one of the best public defenders in Massachusetts and best defense attorneys in Massachusetts. So he asked Sergeant Schmidt on cross, he said, so you said that there was a plastic liner in his Volvo the day before, and then the next day it was missing, and did you ask him where the liner was? And Schmidt said, yeah, and he pointed at the garbage, and Larry Tipton said, did you go get it out of the garbage? And he's like, no. A lot of people point out that, people put plastic sheets in the back of their car when they pick up plants. I do. But again, they didn't retrieve it out of the garbage, but they don't put that in the papers. On the afternoon of January 6th, 2023, MSP Sergeant Yuri Bukhenik spoke with attorney Tracy Miner and verbally arranged for extraction of devices belonging to and used by the defendant and his children. Sergeant Bukhenik's report states. Okay, here's Sergeant Bukhenik's report. On Friday, January 6, 2023, during the afternoon hours, I was provided the contact information for Tracy Miner, who was identified as the defense attorney representing Brian Walshe. During numerous phone conversations, we established a verbal agreement for the digital extraction of devices belonging to and being used by Brian Walshe and his juvenile children, to include TW, 6 years old. Those included his cell phone and his minor children's cell phones and tablets. The agreement which was reached was to include data on the devices beginning on 12/25/22 until the present. See how Yuri selectively puts in his report that it's to include the data on the devices, like all the data on the devices? Have we known Bukhenik's reports to be maybe not so accurate in the past? But I digress. Back to the document. It was communicated to us during earlier interviews that Ana manipulated T's iPad at T's request prior to leaving the home on January 1st of 2023. It would have further narrowed the timeline for investigators to focus on in the search of the missing victim. Footnote 12. In the presence of the defendant's mother, TW told Sergeant Bukhenik that his iPad was not working properly and that his mother fixed it before leaving on January 1st, 2020. The agreement was put into writing by Norfolk District Attorney's first assistant, Lynn Beland. The agreement was then emailed over to me, Sergeant Yuri Bukhenik, and Attorney Miner. Once received, Attorney Miner contacted me over the phone and agreed to the written agreement, stating that Brian would have no problem turning over the devices on consent. The email between First Assistant Beland and Tracy Miner, which I was also CC'd on, is attached to this report. Didn't he also admit on the stand that, or admit that he misunderstood the agreement in the email, and he misunderstood it? I think so. And here's the email so you can decide. In an email dated January 6th of 2023 and timestamp 3:39 p.m., Norfolk District Attorney's Office, First Assistant Lynn Beland wrote, footnote 13 says, she has since retired. Oh, yes, she did. She jumped ship in like October or November of 2024, at the same time David Traub did. And maybe, just maybe, this could be the reason. Olivia Niall pointing out, you know what this shows me? That you can't even trust a consent agreement with the cops. If they get your phone, they're looking at everything regardless of the law, period. Patriotic says, yes, he misunderstood. Yep. Mardo says he's somehow claiming that the oral trumps the written, which she insisted on the written, of course. Yes. Thank you. Here's the email. Attorney Miner, as requested, the Norfolk District Attorney's Office agrees that in the investigation into Ana Walshe's, quote, any conversations between the attorney and client Brian Walshe is excluded from the search and examination of Brian Walshe's phone and TW's iPad. It is further agreed that, quote, any conversation between Brian Walshe and his wife, Ana Walshe, 1 week before she was missing, Christmas Day 2022, and prior shall be excluded from the search and examination of Brian Walshe's phone and TW's iPad. Attorney Miner responded on January 6th, 2023 at 4:04 p.m. We consent to all communications on or after 12:25. If you want to go back further than that, I will have to get you a list of attorneys as he has used a bunch of them. First Assistant Beland responded on January 6th at 4:06 p.m. That date is fine. Thank you. It's up on your screen now. You tell me how you think that agreement between Lynn Beland and Attorney Miner should be interpreted, because they're going to throw a whole bunch of word salad at you. Is BS Yuri's first language? I think it is. We have a word salad emoji for that. Seems to me the agreement was for communications between Brian Walshe and Ana Walshe from Christmas Day until the date of the seizure, of the consent turning over willingly. Remember, willingly, like Jennifer McCabe willingly turned over her phone to law enforcement after she deleted a whole bunch of stuff because they said she could. Communications is the key word here. Communications, not Google searches, not location data. Yuri also testified at the hearing that we watched. He didn't have him sign a consent form because no big whoop. We had an agreement. We didn't need to have him sign a consent form. He said it would be, he didn't say redundant, but he was looking for a word. And I think that that is exactly what he meant to say. But he didn't have him sign a consent, which is another problem in my opinion. On the evening of January 6th, 2023, MSP Lieutenant John Fanning went to the defendant's residence and asked for two devices, the defendant's iPhone and the son's iPad. The defendant mentioned another device, which the son might have used, that he wanted to give police to assist with the investigation into Ana's disappearance. Lieutenant Fanning left the home with an iPhone and two iPads. Remember, Bukhenik also said he didn't talk to Lieutenant Fanning because they sent Bukhenik to DC to look into whether Ana was down there or whether he could find any more, do some detective work in DC. And he said he never talked to Fanning about what to collect or anything because, these guys are never in touch with each other. Prosecute says, yeah, agreement is not a consent form, but then again, it's not a solo cup either. Footnote 14, the defendant also provided the device passwords. He's like, here, take this too. Take this other device that I made creepy Google searches on. Please take it. Is he the dumbest criminal on the face of the earth, or did he trust that? I don't know. You decide. The devices were brought to the forensics lab at the Norfolk District Attorney's Office in Canton. MSP Trooper Connor Keefe, a trained forensic examiner, identified the case as Cohasset missing person in Gray Key and began extracting the iPhone on January 6th of 2023 at 9:25 p.m. Footnote 15. Trooper Nicholas Guarino was also present. 3 gray key reports documenting the extractions are submitted with this opposition. They're actually now, put a pin in this, gonna argue that the extractions were done at a certain time, and so therefore we didn't violate the consent agreement. It's word salad to me, but you tell me if you can figure it out. I've got 3 decades as an attorney, and some of their word salad is confusing to me too, because that's what you do when you don't have anything else, is try and throw a whole bunch of spaghetti at the wall and hope the judge buys it, which in the case of Karen Reed, the judge bought it often without a ruling that was any more than a scribble scrabble on the bottom of the motion. Denied, BJ Cannone, and the date. No legal reasoning, no case law, no nothing. That extraction was completed at 12:28 a.m. on Saturday, January 7th of 2023. The iPad Mini 6 was extracted beginning at 12:33 a.m. and completed at 1:22 a.m. on January 7th. Remember also, that's what Guarino said. They couldn't do all 3 devices at the same time because they only have one gray key machine. So they had to do them one at a time. Trooper Keefe left the office for the night. Trooper Keefe began extracting the second iPad at 10:49 a.m. on January 7th of 2023. That extraction was completed at approximately 11:29 a.m. So I just want to point out that all the devices were left unattended because there's no chain of custody for any of this stuff. In fact, Fanning that got up there and said that he just wrote some reports 5 days ago and backdated them to January 6th of 2023. Sometimes no big whoop. Sometimes it's like, sometimes you write the date of the report. Sometimes you write the date it happened. Yeah, I just did these like 5 days ago. But, no big whoop. All of these devices were left unattended overnight. So Trooper Keefe goes back and begins extracting the second iPad at 10:49 a.m. on January 7th, 2023. That was completed at 11:29 a.m. The 3 devices were returned to the defendant at approximately 1:30 p.m. on January 7th, 2023. So they only had his devices for about 18 hours. Guess who still doesn't have their devices back? Aiden Carney. Go figure. MSP Trooper Nicholas Guarino, also a trained forensic examiner, joined Trooper Keefe at the Norfolk County District Attorney's Office in Canton at approximately 2:45 p.m. on the afternoon of January 7th of 2023. Trooper Guarino began analysis of data extracted from the son's iPad, while Trooper Keefe began analysis of data extracted from the defendant's iPhone. So they're saying they didn't even start looking at the data until 2:45 p.m. on the 7th. And that's when they find the Google searches and the location data. Recorded interview number 3 on January 7th of 2023. All right, let's put a pin in this. So they're saying Guarino gets there 2:45 p.m., January 7th. And that's when they start looking at the data, they claim. Okay. And then the recorded interview number 3 is January 7th, that same day at 1:52 p.m. to Chico, Trooper Michael Proctor, and Detective Sergeant Schmidt, he's Cohasset PD, interviewed the defendant at his residence. Attorney Tracy Miner was present. Police asked for all methods the defendant used to communicate with Ana, including apps, and the defendant provided possible passwords for her accounts. Police asked about financial institutions and learned that at least $200,000 had cleared on December 29th, 2022 from the sale of a property. The defendant looked in his phone for the real estate attorney's name. Attorney Miner said that she would provide the information later. When asked if Ana was pursuing business dealings without him, the defendant said, no, that's not how our marriage worked at all. The defendant discussed business ventures in which he was involved. The defendant said he had paid some of the $450,000 in restitution that he owed in his federal case. The defendant and Attorney Miner said there was no timetable for him to pay the restitution. Attorney Miner wanted him to pay as much as possible before sentencing. The defendant said his goal was to pay as quickly as possible as the case was keeping him from moving to D.C. The defendant and Attorney Miner said that his federal case should have resolved in October of 2022, but had not. Attorney Miner and the defendant said that they were discussing an agreed upon resolution of 6 months incarceration on his federal charges and Ana taking the children to D.C. without him. The defendant got the news about possibly being incarcerated from Attorney Miner just a few days before, and Attorney Miner instructed the defendant not to discuss his conversations with her in front of the police. Trooper DeChico said he had looked at the defendant's monitoring records, noted that he got home shortly after 8 p.m. on Sunday, January 1st. These are the monitoring records of his ankle bracelet that he was wearing for the federal charges, and asked how the defendant received permission to leave his home, footnote 16. The defendant wore an ankle bracelet and needed permission from federal probation to leave the home. The defendant explained that every Thursday he sent an email asking for advance permission to leave the house and that he was supposed to request changes 72 hours in advance. The defendant said that he emailed weekly and, quote, if you go through my emails, they're allowed to look through those, right? And Attorney Miner said, yeah. The defendant said, yeah, you can look through all of those. The defendant said that on Monday, January 2nd, he took his oldest son for ice cream in Norwell. Don't even tell me that it's not pronounced Norwell. Is it something like Norrell? While the nanny watched the younger boys. The defendant did not have his phone, so he could not text the nanny, who looked through the household trash for the phone. Asked if he was concerned about not having heard from Ana, the defendant said he became concerned on Monday. He said it was, quote, weird not to be in contact with Ana, but the same thing had happened the week before, so he was trying not to overreact. I got it right, Norwell, thank you. The defendant said he began calling Ana's work numbers on Wednesday morning and that Ana's sister was upset and going to call the police. The defendant told her to wait because Hugh from Tishman Speyer was going to take care of everything, and he said to let him call police. When Attorney Miner said that the defendant's mother wanted to post a reward, the defendant said it would be $50,000 or more. They agreed to wait to hear from police before announcing any reward. Attorney Miner said they did not want to impede the investigation, and the defendant said, quote, we're working in alignment with you. That's our focus, end quote. The defendant explained that Attorney Miner was present as, quote, a cool head in a time where, the rest of us are not operating really very well. And also, to protect me for, my other legal problems that I'm having, end quote. Oh, thank you, Auntie Bev's Cape Cod Cottage, for coming in here on a holiday weekend and gifting 5 memberships. Thank you. And to those who were gifted, welcome. Police discussed that the public would be suspicious of the defendant having hurt his wife. The defendant said that he understood and that Tracy Miner has prepared me for that. Trooper DeChico said establishing a timeline was important to rule out any suspicion of the defendant quickly. Attorney Miner said, thank God for the ankle bracelet. When the police asked about any other stops the defendant may have made, Attorney Miner said the GPS is going to have that, footnote 17. Police received information from federal probation that the defendant's movements were not monitored, and only the times that he left and returned to the home were recorded. We had a lot of questions about that. Why couldn't they just get the GPS off his ankle bracelet? And here's why. Only the times that he left and returned to the home were recorded. They did not monitor his movements. What is the point then of having an ankle monitor on somebody? But apparently even his attorney didn't know that, because she said the GPS is going to have that. The defendant repeated his description of the time away from home on January 1st of 2023. Imagine, says, what guilty wife murderer would offer up more evidence than asked for and the passwords? Did the boss who came to the New Year's Eve dinner pick her up or aid in her disappearance? I have so many questions. It was eBay Warhol. Look at Tracy. Tracy changed her name to eBay Warhol. Well done, girl. Well done. Why does a 6-year-old have a phone? That's what I was talking about before. And Josh said, thanks, Josh, for your 5. I lived across from an elementary school for over a decade. Every kid walking home was always on their phone. Yep. Higgy is driving the ice cream truck. Happy 4th to you, too. Happy 4th to you, too. Thanks for your 20. Michelle Edwards, welcome. Welcome. The defendant said that during the 4.5 hours they were together on New Year's Eve, Ana had not told their guests that she was returning to DC early, nor had she told him, but he pieced it together. The defendant said that he and Ana had not had specific plans for New Year's Day, but had options as the nanny was coming. Ana had been talking about making a reservation using the open table or Resi applications. As this interview was occurring, a man named Abdullah unexpectedly appeared. Attorney Miner instructed the defendant to tell Abdullah to leave and not to tell Abdullah who was in the house. Attorney Miner noted, quote, there's something weird with this man, end quote, and raised concerns about Abdullah texting Ana on New Year's Eve, stating that they could no longer be friends. Footnote 18. Attorney Miner stated that the defendant called her the night before when Abdullah first showed up. I need to know if they ever looked into this Abdullah, because remember they also got a ransom email from another guy named Richard Walker? Yeah. This gets like weirder and weirder and weirder. Abdullah was, quote, all over the news claiming to be Ana's best friend and had traveled from his residence in DC to Cohasset. Enter Abdullah from stage right, says Lyndon Martingale. Patriotic says, this is the first I've heard about Abdullah. Well, apparently Abdullah traveled from his residence in DC and was all over the news saying that he was besties with Ana. I don't know if we can find any of those clips, but this case is so Abdullah Alagala, that's his name. Thank you, Kim. The defendant said that Ana had been troubled by what happened with Abdullah, who contacted her on New Year's Eve about their friendship being over. The defendant said that in response to Abdullah, Ana said, I'm not going to listen to this. That Ana put her phone upstairs, quote, in our room, or my room now, he's quoted as saying, around 12:15 a.m. The defendant said that Ana used her phone around 10 p.m. when she took photos, including a photo with their 6-year-old son. The defendant did not think that Ana would leave the house without her phone, but if the children took her phone and hid it, she could have used an iPad to arrange a ride and had not brought an iPad from DC. After their New Year's Eve guest left, oh, it's a part of your brain, Kim says, sorry. I'm like, oh, is that the person's real name? Oh, sorry. All right, it's not. Don't go spread false news. False news. It was just a joke. Thanks, Kim. His room now, but I think it was his room because she lived most of the time in DC and she was planning to like move there. And that's why he wanted his case over so he could move to DC too. But did he really say my room now, meaning because she's dead? Because at this time she's still a missing person, right? Moving on. After their New Year's Eve guest left, Ana told the defendant who was in the bathroom that she had to go to bed because she needed to get up early. He said that he chose not to argue about this because he had argued with her when she left early at Thanksgiving and Christmas, and he wasn't going to make the same mistake 3 times. Somebody said earlier in the chat, and it flew by too quickly, that it must have been a pretty important affair to be gone on Christmas Day and Thanksgiving. We can add Thanksgiving in there too. When asked, the defendant denied doing anything to his wife or killing her. He said that they had never had an argument that escalated to physical violence. He said, I wanted to spend the rest of my life with my wife. I'm going to. And, we were apart because of the job and my legal problems. The defendant said that he could not imagine his wife leaving because she loved her job and her family. She could have gone to Serbia, but he had a hard time imagining her doing that. And look, Victory AK86 says the Serbia connection and her recent clearing of $200K significant. Smurf Anna says Abdullah's name is Abdullah Almu Tayari. Thank you. John Monagle said you would think she would want to be home with Chris on Christmas with her kids. Right. On Christmas, especially Christmas morning when they open gifts. She didn't get home until 8 p.m. on Christmas Day. And she drove home. And I'm not victim blaming by any stretch of the imagination. Just pointing out the facts. Attorney Miner asked if somebody got so offended the other day that I said that I was not a fan of tie clips. Okay. Like, you can't even believe what people get offended by. Attorney Miner asked if police had confirmed that Ana had been scheduled to return on DC on January 3rd. Police shared that Ana's return flight reservation had not been canceled or adjusted. The defendant asked if police had, quote, any of the chatter between JetBlue and her over the last few months, because when she doesn't call, she does something, they do it online, like online messaging through JetBlue. I know what that is. It's live chat, because it's impossible to get somebody on the phone. A live chat through JetBlue is the way to do it, in my opinion. Attorney Miner stated that she herself used JetBlue's chat feature and that the service included website live chats. The defendant said that Ana would sometimes try to change flights and go back and forth with JetBlue online. Ana never called them. The defendant usually paid for things with credit cards, typically a Chase Freedom card. He agreed to provide a list of his credit card transactions so police could narrow down his travel. Attorney Miner agreed to provide his credit card statement for December 2022. The defendant said, yes, absolutely, we'll get it for you. How much of the Chase Freedom would you like? I mean, he's offering up so much information. Footnote 19 says, Trooper DeChico said 31st through, Attorney Miner said, we will give you all of December if you want. Okay. It still doesn't mean you can search his phones outside of the consent agreement. When police asked for paper documents of Ana's credit card transactions, Attorney Miner said, I have dealt with Ana. I'm trying to get financial information for the federal case. She does everything online. I'm a paper person. Police asked if the name Richard Walker meant anything to the defendant. Here we go. Footnote 20. At 5:18 a.m. on January 7th of 2023, Cohasset police had received an email from Richard Walker 9984 at gmail.com stating, we have the so-named Ana Walshe with us here. We had a deal worth $127,000. She messed up. We have her here with us, and if she doesn't pay the money, then she'll never be back. Know that the police and the FBI are involved. ... Good luck finding us. That was at 5:18 a.m. on January 7th. Search warrant 23 SW0033 for data associated with the email account Richard Walker 9984 at gmail.com, issued on January 7th, 2023, and the return was filed on January 8th of 2023. On January 9th of 2023, the account information was received from Google. Except we don't know what that was. And JL Street says they leaked those searches early on. And then Bentley RM says, who uses the Gmail account for a ransom email? Right, a named Gmail account. Right. You can't make this up. Police asked if the name Richard Walker meant anything to the defendant. Attorney Miner noted a pending civil lawsuit in California, which the defendant said included Ana as a defendant. The defendant said that someone from that lawsuit threatened Ana on Facebook and tried to contact her in 2018. Attorney Miner said that she did not think the defendant's federal case had anything to do with Ana's disappearance. When Trooper DeChico said he wanted to, quote, leave no stone unturned, end quote, Attorney Miner said she did not want to talk about the defendant's open criminal case. Oh, is that an excuse for your piss poor investigation? Because even though DeChico said he didn't want to leave any stone unturned, maybe he did leave that stone unturned because, they wanted to close the case quickly. They wanted a conviction. I don't know if he did it or not. But I've seen this film before. Luckily, I had to see the film twice until I liked the ending in the Karen retrial. Attorney Miner said that she had informed Lieutenant Fanning that the defendant's mother hired a private investigator to operate in LA or DC. Attorney Miner asked if that investigation should be terminated, but could not promise that the defendant's mother would listen. Attorney Miner said that if the private investigator comes up with anything, we're going to hand it right away to you guys. Right. Esther says, how do we know Brian made those searches and not Ana? Especially if the 6-year-old is saying she was fixing his iPad that morning when the searches were made. Because now all of a sudden, the Celebrite information is going to be 100% accurate with regard to the time of those Google searches. And those Google searches were all made before Ana allegedly left the house 7 a.m. Some of them I think were after, but are timestamps really a thing? Does it revert back to like the original time the tab was opened? Can we get Ian Whiffen to come in and testify? Olivia says, I thought they were just corrupt and not incompetent in Karen's case, but it looks like they're both. This is bad. This is bad. Attorney Miner noted, sometimes it's not a bad thing to have second person around. I know nobody likes it because I don't ever like it when they get into my business. Trooper DeChico said he would speak with supervisors. The interview ended at 3:36 p.m. Later that afternoon, Trooper Connor Keefe determined that the iPhone had been manually unlocked on January 1, 2023, at times when the defendant had claimed it had been misplaced, and noted location data for January 2nd of 2023. They're admitting they're outside the scope of the consent agreement. That same afternoon, January 7th, they didn't have a warrant yet. Connor Keefe testified at the evidentiary hearing. We watched him testify. Showing that the phone had been at Home Depot in Rockland from 4:12 p.m. until 4:56 p.m., as opposed to being at Press in Norwell for ice cream with his son, as he had told investigators at the January 7th interview. But here's the thing. They weren't supposed to be looking at the location data. At approximately 6:24 p.m. on January 7th, 2023, Trooper Guarino emailed the other officers about a series of searches regarding the disposal of a human body beginning at 4:52 a.m. on January 1, 2023, which he found on the iPad mini. Uh-oh. They weren't supposed to be looking at the Google searches. Just communications. We don't need no stinking warrants. On Sunday, January 8th, 2023, police obtained search warrant SW 0034 for 516 Chief Justice Cushing Highway. It was executed that day at 8:52 a.m. Okay. So let's just recap. Based on the information that they found, the Google searches that they weren't supposed to be looking for, the location data, and the Home Depot information, Michael Proctor wrote a search warrant for the house. And Michael Proctor, in his affidavit of probable cause, listed all the Google searches as probable cause to search the house. Who can tell me what's wrong with that picture? And I have it. I have the probable cause affidavit. Yep. They did the same thing to Turtle Boy, says Arcus Chicken Gun. Seems to be like this is just what they do. Is this just what they do? Because remember, this is January 2023. When did they do that to Aiden Carney? Something like October 2023, same year. Rid of the poisonous tree. Asher Jones, the electronics data have a chance of getting kicked out because of a shit investigation and corruption. Yep. Cuzco wants to know, why is there always a Home Depot visit involved in these crimes? Right. Magnolia Gypsy again, no warrant and outside the consent decree. Yep. So they get the search warrant on January 8th, and then they go search the house at 8:52 a.m. Among other things, the warrant authorized the seizure of electronic devices, including the 3 previously returned to the defendant. So yeah, that's what happened. What had happened was they seized his devices on the 6th. They took him back to Norfolk County DA's office, hooked him up to Gray Key, left him unattended overnight, returned them to him on the 7th, and then on the 8th, they get a warrant to search the house, and then they take the devices again. They re-seize them. And their argument's going to be, no big whoop, no biggie, because we would have gotten this information anyway. Except the probable cause affidavit for the search warrant lists all of these things that were illegally obtained. See? Footnote 21. On January 9th of 2023, police obtained warrants to search digital devices seized from the defendant's residence. 1 MacBook, 2 MacBook, iPad mini, iPhone mini red, another MacBook, iPhone black, iPad A2, and iPad 6. So they got the search warrants to search the digital devices on January 9th. But remember, they took him on the 6th, did total extractions on his phone and the 6-year-old's iPad and another iPad. And that's how they got all their information. But they didn't get their search warrant till January 9th. But they don't think that there's anything wrong with that. Police allowed the defendant and his family to get dressed. Oh, unlike Karen Reed, I don't think they wanted her to be able to put her pants on or underwear. But I think eventually they did, maybe. I don't remember. The defendant, his mother, and 3 children went to Attorney Miner's house while the search was performed. Police went to Attorney Miner's home to speak with the defendant. Troopers Proctor, DeChico, and Sergeant Schmidt interviewed the defendant in Attorney Miner's presence. That's a great point, Josh. I'm going to highlight that for later when we get to that point. Thank you. And here's recorded interview number 4 on January 8th, 2023. The interview began at 11:13 a.m. Police reviewed the defendant's prior statements about Ana leaving around 6 or 6:30 a.m., the defendant staying in bed, and that he got up around 7 or 7:30 a.m. to make breakfast. Attorney Miner had receipts from places that the defendant visited on January 2nd of 2023. We have Press, which he told you about, Shaw's, which I think he told you about, and Shake Shack. Trooper DeChico commented, there's a lot of electronic devices in your house, and you've been kind enough to consent to downloading several of them, one of them being the iPad mini that the defendant's 6-year-old used. Asked if he used devices other than his phone, the defendant said that he only used a gold laptop and that all household devices, with the exception of Ana's worktop computer or Ana's work computer, were Apple. Trooper DeChico then said, so again, we downloaded the iPad mini, and you've been fairly consistent in your story and your account of the morning, and you said that Ana gave you a kiss about 6:30 in the morning. After the defendant confirmed he stayed in bed and then made breakfast at 7:30, Trooper DeChico asked, how would he explain that the iPad mini was querying the 10 best ways to dispose of a human body at 4:54 a.m.? The defendant said, I have no idea. The defendant said that his son had the iPad in his room, and I don't use that iPad, so it's really weird. So they're questioning him about the Google searches that they illegally obtained on the 8th. Because remember, they didn't get the search warrant until the 9th. Trooper DeChico pointed out that the son was 6 years old and noted dozens of searches on that iPad on the morning of January 1st for things that I'm not allowed to say on YouTube. How to dispose of a human body, how to get blood out of floors, how to dispose of a human body in a trash, how to stop a body from decomposing, and all the things that I have to rush through because YouTube doesn't like them. When Trooper DeChico said, so you're not using that iPad? The defendant said, no, sir. I mean, I only get it for his spooky movies. Apparently he's letting the 6-year-old watch spooky movies. I have a lot of questions about a lot of things. Attorney Miner said, well, Ana could have used it too, obviously, noting that Ana had reportedly left at 6 a.m. No, it was between 6 and 7. So even the Commonwealth in their papers doesn't get it right. But we're paying attention, as is the judge. Because remember, during the hearing that we watched, the judge kept butting in and saying, wait a second, I'm noticing the Google search says January 27th of 2023. Do you really mean December? Because this is all wrong. And she got it. Well, we'll get to the judge that signed the search warrants. Thanks, Grace. It's a clerk magistrate. Oh, wait. A clerk magistrate named Judge Looney. No, you can't make that up either. Judge Looney, Looney. I don't even know if it's a judge. It seems like a clerk. Judge Looney, or John Looney, who used to be Guess where? Well, he's in Quincy District Court now, but he used to be with the Norfolk County DA's office. He was an ADA there. Anybody know John Looney? Looney? Trooper DeChico noted that the device continued to ask how to get blood stains. Does the dishwasher remove blood from a knife? Throughout the afternoon of the 1st, when Ana was gone, Attorney Miner terminated the interview at 11:21 a.m. and police left the residence. Looney has spoken out about Karen Reed, says KBD. And Grace says Looney and Quincy now. That's right on the money. I don't know, El. How do you get demonetized for that stuff? But I go on other lawyers' channels and they're smoking out, swearing like 16-year-old high school punks. I don't know. I try and keep it clean too, right? You know, I don't curse a lot unless it's really, really warranted and it just slips out. On January 8th of 2022, the police got a search warrant to search the defendant's residence for, among other things, electronic devices, including the 3 that had been extracted and searched with his consent and then returned to him. The defendant was arrested later that day for misleading police. On January 9th, the police sought individual search warrants for the contents of each electronic device seized from the house and the defendant's Volvo. On January 18th, the defendant was arraigned for the taking of his life, we'll call it the M word, of Ana Walshe and disinterment of a body. Footnote 22. Quincy District Court. That happened in. That's where he was arraigned, in Quincy District Court. On March 30th of 2023. Right. Why get a warrant if you've already searched the devices, says Goblin Tie Clip. No fun with the tie clip. Got in trouble for saying that. Somebody got so mad. Remember when Guarino was on the stand? And he said, oh, and I found all of these Google searches and then I stopped. And I said, why did he stop? Because he knew consciousness of guilt. He knew he did something wrong. And then Larry Tipton gets up, and I had not watched this before, I swear to you, and said, why'd you stop? That was the first question out of his mouth. Why'd you stop? After you found the Google searches, why'd you stop? Disinterment. Yeah, why does it say disinterment? Does that say dismemberment? Hold on a second. Disinterment is a word, and it's the act of digging up a body from its burial place, essentially exhumation, right? So they do that when they want to exhume a body to test it for DNA or other things. So again, this is the Commonwealth's papers, so I don't know. It probably is supposed to say dismember, but we're not allowed to say that either. Again, disinterment of a body, like digging it up. That's not the right word. On March 30th of 2023, he was indicted for the M of Ana Walshe, witness intimidation. Oh, witness intimidation. They're using that against him too. Weaponizing that statute. Interesting. On February 20th of 2024, represented by Attorney Miner, the defendant was sentenced in federal district court by Judge William Young, 23. Those are the other charges. Judge Young imposed a committed sentence of 37 months, a 3-year probationary period, and restitution of $475,000. Committed sentence? Is that like you have to be in your house for 37 months? So that happened in February 2024. That's a year after. Remember, these papers were just filed a couple weeks ago. Right, so he dug up a body they haven't found, Danny? I don't know, I'm confused too. Clip-on ties are fine. Clip-on ties are fine if you're 6. Thanks for asking, Grace. And remember, Nikki says, the Commonwealth doesn't think there's anything wrong with copy and paste and not double checking that it's right. Exactly. Okay, here's their argument. The defendant freely and voluntarily consented to searches of 3 digital devices for data from December 25th of 2022 to the present. The searches were conducted within the scope of that consent. The incriminating matter was in plain view, and discovery of the material was inevitable. Wow, that's a lot to swallow, isn't it? Number one, he consented to it. Number two, the stuff that we found, the Google searches were in plain view. Yeah, hidden inside a Google search folder or something on the device. And the discovery of the material was inevitable. That's what they're arguing. Yeah, plain view, exactly. Let's get there. Review of the defense and how they make these arguments with a straight face is beyond me. Review of the defendant's statements and conduct and conversations between Attorney Miner and the MSP and the Norfolk District Attorney's Office demonstrate that the defendant freely and voluntarily consented to searches of all data on 3 digital devices beginning December 25th, and that police honored the scope of the consent. Yeah, they're making that argument in good faith without laughing. Based on defendant's statements and conduct and conversations between Attorney Miner and the MSP. All data. I read the email. What do you think? Evidence that the iPhone had been manually unlocked on January 1, 2023, when the defendant said it was missing. Location data showing the iPhone at a location the defendant had not disclosed to the police. And the incriminating searches on the iPad were within the scope of the consent and were in plain view given the scope of the consent. They were in plain view. Plain view. Let's talk about when you can see something that's in plain view. If you maybe say there's a traffic stop and an officer pulls over a person for, speeding. And as they do, they shine their light on you when they come over to your window. And you better by the way, just put your hands up on the wheel. And in plain view on your passenger seat is a weapon of some sort. That's in plain view. Let's see how they stretch it on this. Where police had probable cause to arrest the defendant for misleading police independent of information from the devices, and the devices had been returned and were seized from the residence on January 8th, 2023, and police obtained warrants to search them, discovery of the information on the devices was inevitable. Yeah, because we searched them and then we gave them back, and then we got a search warrant to seize them again. And so inevitably, we would have been able to search them and we would have found it anyway. So no big whoop. No biggie. Yeah. Roman number 1, the defendant freely and voluntarily consented to searches of the 3 devices for data beginning on December 25th to present. A search may be conducted without a warrant, provided that the search is undertaken with a free and voluntary consent of a person with authority to give that consent, citing a bunch of cases. The voluntariness of consent is a question of fact to be determined in the circumstances of each case. They also didn't have him sign the consent, form. While the Commonwealth bears the burden of proving consent, neither probable cause nor reasonable suspicion are required to ask for consent to search. Okay, but you didn't. You just did it. While consent may be freely and voluntarily given, there's no requirement that it be knowing and intelligent. Police are not required to disclose their reasons for seeking consent. Consent is free and voluntary where it is unfettered by coercion express or implied, and must be more than mere acquiescence to a claim of lawful authority. A voluntariness determination requires consideration of the totality of the circumstances. An attitude of cooperation is relevant to evaluating consent. Police first met the defendant on January 4th after they went to the house in response to a request for a well-being check by Ana's employer. The defendant told police he had last seen Ana on the morning of January 1st, wanted to assist with the investigation into her disappearance, and freely shared information about his family's electronic devices. That evening, he showed police a text chain of Ana's travel information on his phone and said, "Here you go. You can look at you can look through all that, but that's the last one she sent me. You can take a look at that, whatever you want to do with that." When Detective Sergeant Schmidt recited Ana's itinerary, the defendant said, please look at it. Anything that's going to help you, please look at anything. Again, before he spoke to his attorney. The defendant said she had a day with T, so she sent me some videos of that, and then you'll get into the area where I start texting her, and she doesn't return to me. And if you want to look further, there's probably a year's worth of text there. Exactly. Hannah needs to yell, says totality. He changed his mind and wanted to speak with his lawyer. Yeah. Brady, no, in my opinion, data is not the same as communications. No, communications is, two people communicating with each other, right? And it could be via email, via text, via WhatsApp or Signal or Viper. But it's not location data and it's not Google searches. And that's a great question, Brady Star. Thank you for that. Athena, who's a lawyer, says, maybe a lawyer, new rule of evidence, inevitable discovery invalidates fruits of the poisonous tree. LOL. Yeah, that's what they're arguing with a straight face. The defendant also stated that Ana had used his phone and that her iMessages sometimes appeared on his phone. The defendant allowed Detective Sergeant Smith to examine the camera roll on his phone and said, anytime you want to go through this, feel free. The next day, when asked if he ever had a physical confrontation with his wife, defendant said, please feel free to ask any questions that you have. Don't worry about me being offended. I understand that you're here to find Ana. You're working for her. Asked if he had hurt his wife. He said, no, sir. I wouldn't hurt my wife. I love my wife. I mean, we all want to have her back. This family doesn't work without her. And then we can't function without my wife. The request to download his phone was made during the second recorded interview. Is described out of context in the defendant's memorandum in support of his motion to suppress. We went over those papers, I think, in the first stream up on this 3-video series. Police did not repeatedly assure him that they were only interested in communications between Ana Walshe and him in an effort to learn more about Ana Walshe to induce the defendant's consent. Rather, Trooper DeChico said that police were hoping to create a permanent timeline of events of the 1st and the 31st and 1st, and maybe get a better insight into Ana. Is that something you'd be okay with? And then we read all of this before, where he said, yeah, downloads everything while we're in blah, 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 blah. And then he mentions Tracy Miner, and all this is just kind of like regurgitating what they've already said in the first pages of this, where the defendant told police he did not use the iPad and he volunteered a second iPad to Lieutenant Fanning. The defendant could not intended the consent to be limited to communications. The defendant's personal characteristics are relevant to assessing the voluntariness of his consent. The defendant did not merely acquiesce to authority. He actively participated in discussions and negotiated the terms of his consent. When the defendant said, so just to be clear, you want to download everything on my phone, police did not try to conceal the technology they would be using. Yes, they magically have recordings of this. This was in 2023. Trooper DeChico told the defendant that with the extraction, we'll download all the contents of your phone. The defendant inquired about the logistics, including how long the download would take and where it would occur. Told it would depend on the size of the device. The defendant described his iPhone as 128 gigabytes or something. And then they go on to repeat the conversations that we talked about earlier, that he wanted to talk to his attorney. And the Commonwealth says the discussion moved on to another topic, and there was nothing coercive about the interaction. True to their word, police did not take the defendant's phone from him. Because, he wanted to talk to his attorney first and said, come back tomorrow. The defendant was a competent and sophisticated adult who knew he could refuse consent. The defendant was a 47-year-old married father managing a household and 3 young children while his wife worked at a high-paying job in D.C. His work included substantial business deals, such as a cybersecurity business in which he had invested around $80,000, which he explained involved high-functioning teams and potential contract with a foreign government. He had experience with the criminal justice system, was on supervised release for a federal crime, was negotiating resolution of that case, spoke of his dealings with FBI over art fraud, and invited officers to read about it in the papers, or the papers. He politely declined to consent to a search of his phone until he had a chance to speak to the attorney representing him in that pending federal case. He contacted that attorney before deciding to consent, and that attorney helped negotiate the consent. That the defendant was aware of his ability to decline consent is further shown by his decision not to bring his children to forensic interviews after having agreed to do so. Patriotic says, notably, all of this was after the misconduct in the Karen Reed case, but before they got called out about that misconduct, so they probably never thought this would be questioned by anyone or put on blast. Right. That's right. Consent may be inferred from actions. Almost 24 hours elapsed between the request for consent and the defendant handing 3 devices to Lieutenant Fanning. Yeah, and there was an agreement in writing. This is so beyond the pale that they're arguing this in good faith that I don't even know what to make of it. Almost 24 hours elapsed between the so then he gives Fanning 3 devices. And you can go back and watch the hearing because they testified about all this stuff. Although Sergeant Bukhenik, Attorney Miner, and the Norfolk District Attorney's Office referenced 2 devices, after inviting Lieutenant Fanning inside and providing his iPhone and his son's iPad, the defendant searched for a 3rd device, an iPad with a cracked screen, and that he wanted police to have for the investigation into honest disappearance. That the defendant volunteered to find another device that could help with the investigation, located it, and gave it to Lieutenant Fanning demonstrates his consent. We saw Fanning testify also. While iPads were not discussed during recorded interviews, in the presence of the defendant's mother, the defendant's 6-year-old son told police that Ana fixed his iPad shortly before she left the house on January 1st. Sergeant Bukhenik's report about his January 6, 2023 conversations with Attorney Miner also notes that the iPad was reported to have been manipulated by Ana Walshe shortly before she left the house. So basically what they're arguing here is that all of these verbal communications and agreements should trump the agreement between Lynn Beland and attorney Tracy Miner, which seems pretty clear to me. But then again, I'm just a lawyer. I'm just a lawyer with a microphone who likes to scream out into the universe about things that I find to be unconstitutional. And here we are again in Norfolk County. Shocked? I'm not. And then they go on to make some more excuses about why they didn't do anything wrong. And we told them it was going to be a whole entire dump. Doesn't matter. No big whoop. No biggie. I'll scroll through this slowly so you can come back and read it if you like later. Then they go on to say, he said that he intended to provide consent but wanted to speak with Attorney Miner before doing so. Although his wife was missing, the defendant was not suffering from excessive stress, confusion, or anxiety, or under the influence of drugs or alcohol. Audio recordings, which the Commonwealth will introduce at the hearing, show that he was calm, polite, and cheerful, and that he did not cry, lose his composure, or seek breaks. He nonchalantly described running a variety of routine errands on January 1st and thereafter, and was not particularly concerned about not being in contact with Ana, as something similar had happened before. Rather than being alone, he was surrounded by supportive people. The nanny was there, they say. His federal attorney was there. She was helpful. And then he had a lot of advice coming his way. He told them on the 6th. His mother had offered a substantial financial reward. So he had a great support system. And therefore, you can't say he was coerced. The defendant argues incorrectly that the police engaged in misrepresentation and deceit because they traveled to the locations where he had claimed to have been on January 1st. At the second recorded interview, when asked to describe what he did on Sunday, January 1st, the defendant explained that he had gone to see his mother and went to Whole Foods and CVS. At the third recorded interview, police told him that they intended to develop a timeline of the defendant's whereabouts because the public was going to be suspicious that he had done something to Ana. The defendant responded, "Tracy Miner has prepared me for that." Trooper DeChico explained, quote, "It's important for us to iron out a really good timeline for you. And we vet that out. And it's going to help us rule out any suspicions of that even quicker. And I think that it benefits both of us. so we can move on. And that's part of the reason we asked you for that timeline as to what you did on Sunday and Monday. Again, with the timeline. The Chico tells him it's going to help us rule out any suspicions of that even quicker. And I think that benefits both of us. Timeline. Who told Jennifer McCabe and Carrie Roberts to write a timeline? I really want to know. And I have more questions. More questions. Because Jennifer McCabe said it was Peggy O'Keefe. And now I think maybe it was Proctor or somebody, because this is what they do. Yeah, we just want to rule you out, make a timeline. I don't know. That the defendant and Attorney Miner understood police wanting to rule out suspicions about the defendant being involved in Ana's disappearance was also shown by the references to the defendant's federal monitoring. During a discussion of the defendant's whereabouts on January 1 and 2, Attorney Miner said, "Thank God for the ankle bracelet. And the GPS is going to have the route and stops that the defendant made on January 1 and 2. It was abundantly clear to both the defendant and Attorney Miner that the police were stating that they intended to verify the defendant's whereabouts as part of the investigation into Ana's disappearance. When police did so on the evening of January 7th, they discovered that he had not been truthful." Footnote 26. At approximately 6:30 p.m. on January 7th of 2023, troopers reviewed surveillance video from Whole Foods in Swampscott and the North Shore CVS stores the defendant said he visited on January 1 of 2023. He was not observed to enter those stores when claimed, and those CVS stores had no records of anyone purchasing the items that he reported purchasing. So they didn't find any video of him there. So then they're going to charge him with misleading an investigation in order to backdoor the inevitable discovery of what they would have found. Hey, if you can make sense of it, please throw a comment in the chat. Then their second point, Roman 2, is the search of data extracted from the devices was within the scope of consent. The Oakley, I'm going to star that for later. What, if any, limitations on the consent are implied by the language or conduct of the consenting party is a question in the first instance for the judgment of the police officers to whom the consent is given. This is citing a case called Fencher from 2018. The ultimate question is whether, in light of all the circumstances, a man of reasonable caution would be warranted in the belief that some limitation was intended by the consent giver. The standard for measuring the scope of a suspect's consent under the Fourth Amendment is that the objective reasonableness. What would the typical reasonable person have understood by the exchange between the officer and the suspect? Yeah, but here they have a written consent agreement. It's written between attorneys. And then they're going to go on to talk about what DeChico told him. And Bukhenik's conversations with attorney Tracy Miner that we saw him testify to on the stand. And because Bukhenik's report notes that the agreement was, quote, to include data from the devices beginning on 12/25/22 up until the present, end quote. And then the Commonwealth says this verbal agreement was memorialized in an email which stated that the Norfolk District Attorney's Office agreed to exclude all communications potentially subject to the attorney-client privilege, end quote, any conversation between the attorney and client Brian Walshe, and conversations that could fall within the marital privilege prior to December 26th of 2022. Quote, any conversations between Brian Walshe and his wife, Ana Walshe, 1 week before she went missing, 12/25/22 and prior. And then have the cojones. ADA Beland's email did not limit the search to communications. The email stated only that the search would exclude all attorney-client communications and marital communications prior to December 26, 2022. Attorney Miner, who would know the extent and nature of her communication with the defendant, responded by expressing concern about attorney-client privilege communication related to the federal case. We consent to all communications on or after 12:25. If you want to go back further than that, we'll have to get you a list of attorneys, as he has used a bunch of them. That Attorney Miner's concern as to the search of the devices was attorney-client communications is further demonstrated by her remarks during the recorded interview. She told the defendant not to talk about conversations he had with her. She told police, "We don't want to talk about the criminal case." Trust me, bro. That's exactly what this is. After extracting the devices, police examined the data using the timeline feature of the software to view the materials from December 25th of 2022 to the date of consent, which was January 6th of 2023, ensuring compliance with the defendant's consent and avoiding discovery of potential attorney-client communications prior to December 25th, 2022. Police only searched data from December 25th of 2022, a week before Ana's disappearance, again demonstrating that police were focused on information about Ana. This was reasonable, where police knew Ana was in Cohasset on December 25th, 2022, and had returned to Cohasset on December 30th, 2022. Police knew that Ana's phone was stationary at the house from New Year's Eve until it went off, and in the early morning hours of January 2nd. Police also knew that Ana was reported to have fixed the son's iPad shortly before she departed, January 1st. The defendant told police that if the children had taken Ana's phone, Ana could have used an iPad to arrange transportation to the airport with Uber or Lyft. The iPad could have been used to communicate with the JetBlue chat feature that Ana was described as using. Further, Ana was potentially planning to go to brunch for New Year's Day and was known to book reservations through OpenTable or Resy, where Ana could have used the iPad to arrange transportation with a rideshare service, modify her JetBlue reservation, or make reservations for brunch. Police reasonably sought consent to search for data on December 25th, 2022 and later. Police honored the scope of the defendant's consent. Again, they're still sticking to the story that the consent that they gave in writing wasn't just for communications between Ana and Brian. So we didn't do anything wrong. And that's going to be up to the judge to decide. In sum, police honored the scope of the defendant's consent to search the devices. But, Your Honor, if you don't like that argument, here's our next argument. In the alternative, suppression is not warranted, as the fact that the iPhone had been manually unlocked on January 1 of 2023 and its location data on January 2nd, 2023, and the iPad searches relative to disposal of a body were in plain view on data extracted from the devices. Collusion. Can't prove a collision, says, why would the attorneys be discussing search limitations via email if the defendant had consented to a full search? They wouldn't. Exactly. Thank you. Figure 10. In the alternative, the use of the iPhone on January 1st, its location data from January 2nd, and searches on the iPad were in plain view. The SJC has held that where the location of evidence on a cell phone is unknowable to law enforcement, the Doralass requirement that the officers identify the file types to be searched in the warrant is impractical. Footnote 28. One moment, please. Plain view. Wait, let's footnote 27. Oh, presumably the defendant would not have kept business or personal information on the iPad described as belonging to his 6-year-old son used by his young children, and which he said he used only to find spooky movies. Oh, so it was okay because there was there wouldn't be any attorney-client privileged information on that. And footnote 27 says, in the first recorded interview, the defendant noted that his son was allowed to sleep with his iPad. In the second recorded interview, the defendant reported that when he went downstairs at 7 a.m. on January 1st, 2023, his son was on the couch playing with his iPad. During the second recorded interview, the son asked the defendant for help finding his iPad, and the defendant told police, "I made a terrible mistake giving them iPads at a young age, and now that's ruined everyone's life now. Remember when they didn't have electronics in bed when we were younger?" I don't know what that's there. And then they cite a case, Commonwealth v. Dorlass from 2016, saying that plain view. I haven't read the case yet, honestly, so I can't comment on it. But they say that according to, quote, although general or exploratory searches are not permitted, requiring a search warrant application to identify specific locations or files on a cell phone to be searched places an unrealistic burden on law enforcement and restricts legitimate search objectives given the storage capacity and file structure of most cell phones. Well, I think that case is easily distinguished because they didn't have a warrant. They didn't have one. This was on consent. And then they go on to cite another case from 2017 that says digital search protocols are not required in Massachusetts. Well, okay. And a 2015 U.S. Supreme Court case that says, in most cases at the time of the seizure, officers are unable to know where the information is located in the phone or in what format. Again, there was no warrant. This is not a file type kind of case, says Lyndon Martingale. Alternatively, even if, as the defendant alleges, the consent only allowed examiners to look at communications between more than one person, examiners would nevertheless have seen the internet searches and GPS location data in plain view on the timeline feature of the software. Citing a U.S. Supreme Court case. When the incriminating internet searches were discovered on the iPad on the evening of January 7th, 2023, Trooper Guarino notified supervisors, ceased his examination, and began working on a search warrant. Well, interesting, because they didn't get the warrant until the 9th. So what took so long? Because you'll see when we look at a search warrant that some of them are seem to be signed in the middle of the night. On January 8th, 2023, police obtained a warrant to seize the devices, then subsequently obtained warrants to search the contents of the devices, but they had already searched them. Yeah, wait, they searched a 6-year-old's iPad, but not Brian Higgins's phone before he got rid of it? Yeah, well, he was one of them. And Your Honor, if you don't like that argument, here's a fourth argument for you. Separate from the consent search of the devices, the information found on the devices would inevitably have been discovered. The 3 devices searched pursuant to the defendant's consent were returned to the defendant before the extracted data was examined. These devices were inside the house on January 8, 2023, when search warrant 34 was conducted at 516 Chief Justice Cushing Highway and were seized by police. Police obtained separate warrants to search the devices and re-extracted them. Oh, they re-extracted them? Do you think that's true? Do you think that they re-extracted them, or they just used the extractions that they had already because they already did it, even though they didn't have a warrant? Because you know what? Nobody has ever called us out on it before. Why would they now? Before examining data extracted from the devices with the defendant's consent, police had probable cause to charge him with misleading police, as a review of the surveillance video confirmed that he had not traveled to the swamps, get Whole Foods or CVS, and made purchases for his mother, as he repeatedly told police when he described his activities on January 1, 2023. The New Year's Eve guest told police that he left the residence around 1 a.m. on January 1st. The defendant and Ana were the only adults in the house, and everyone was enjoying themselves and in a good mood. The defendant had not reported that Ana was missing until Cohasset police arrived at his residence to perform a well-being check. Ana's phone was pinging in the area of the defendant's residence from New Year's till January 2nd when it went off. There was no record of Ana leaving for the airport by Uber or Lyft, as he had not used her credit cards, or she had not used her credit cards or banks her credit cards of banks on January 1st or later. She had not traveled by plane or train. Searches in the area of the residence produced no evidence of Ana, who was entered the NCIC as a missing person on January 4th. There was no evidence of her being at her DC residence, nor was there evidence of foul play at her DC residence. Right. Everyone was enjoying themselves, and it's such a good movie. We heard that somewhere before. Smurf, I know we did. Police knew that the defendant had possession of the iPhone and iPads, and that Ana was reported to have fixed the son's iPad. He said that when he found his phone on January 2nd, he began texting friends and family, inquiring if they had heard from Ana. If police had not examined the iPhone and 2 iPads with the defendant's consent, they would have inevitably discovered these devices upon issuance of search warrants authorizing police to seize the devices and search them in connection with the defendant having misled police. And if you don't like that argument, here's a 5th one. Where police were searching for the defendant's missing wife and the attorney who represented him in his unrelated federal art fraud case was present as a, quote, cool head, end quote, actively assisted with the missing federal person investigation, and sought only to avoid any discussion of the pending federal case, that attorney cannot be deemed to have provided ineffective assistance of counsel by assisting with the terms of a consent search of the defendant's devices. They go on to say, in a footnote, the defendant alludes to the possibility of ineffective assistance of counsel. Because remember, it's Larry Tipton representing him now. Tracy Miner represented him in the federal art fraud charges. And here's the footnote. It would clearly have been ineffective assistance of counsel to turn over any electronic device for such an extraction without limitation under the totality of the circumstances present here, without first conducting an investigation and exercising due diligence before advising the defendant or to negotiate a flawed agreement. See Commonwealth v. Celester. If evidence or findings resulting from a hearing conducted on the defendant's motion suggest that there was no limiting agreement or it was negotiated in a flawed matter by the defendant's attorney, the defendant reserves the right to move to suppress the evidence and information based on ineffective assistance of counsel. Unlike in Celester, where counsel was deemed ineffective at a custodial interview of a defendant for whom the police had a murder warrant, this was not an investigation into a crime, but a search for the defendant's missing wife. The defendant welcomed police into his home on the morning of January 4th. That evening, he welcomed 2 officers into his home and participated in the first recorded interview. He again welcomed officers on January 5th of 2024. For the second recorded interview, he allowed police to speak with his 6-year-old son. When the defendant expressed concern about that case and his desire to speak to Attorney Miner, who represented him in the unrelated federal case, he was assured that no one's taking your phone from you. He said that Attorney Miner had heard about what was going on and contacted him. The request to search the defendant's devices in this investigation into the disappearance of his wife is materially different from investigations into violent deaths and in cases addressing ineffective assistance of counsel when suspects are interviewed by police. When police first went to the defendant's home, there was no evidence of a murder. Police were there because Ana's employer reported that she was missing. Police raised the possibilities that Ana took her own life, was kidnapped, or had gone to Europe. When police obtained the defendant's consent to search the devices, they did not know where Ana was or if any crime had been committed. Attorney Miner entered the interview when it became apparent that the searches suggested a crime. Conclusion: where the defendant freely and voluntarily consented to searches of the 3 devices he handed to police, the search did not exceed the scope of his consent, the information was in plain view, and the information would inevitably have been discovered. The motion to suppress should be denied. XOXO. Greg Connor, Assistant District Attorney, Norfolk County. And here are the impounded attachments to this: the recorded interview transcripts, the recorded audio files, Trooper Connor Keefe's CV, Nick Guarino's CV, Gray Key progress reports, January 7th email from Guarino, Trooper Reno, which I guess notified Fanning of the searches, NCIC missing persons report, extraction report from Celebrite iPad Mini, which is 174 pages long, the Richard Walker email to Cohasset Police, and a police report of Sergeant Bukhenik and Detective Lope's interview, and a report regarding the search warrant to Google. That was for the Richard Walker email. They just do what they want. They just do whatever they want. That's what they do. That's what they've been doing for a long time. And look the other way. Let's go to the chat. For questions. Live Mr. Ducks, thanks for your 5. Off topic, but what is your skincare routine? Your skin looks so soft. Love your face. Well, it's a good ring light. it's a side light coming from my other screen. And I was out in the sun today. So, moisturize. Stay hydrated. Stay hydrated. Thank you. Thank you very much. I feel like I have a little more color. I felt so pale in the winter. Moisturize. Sunscreen. Josh, can the defense get Bukhenik's call logs to show he actually spoke to Miner? Are they discoverable? I don't know. But what I found of interest, because after the hearing, they were allowed to submit more papers, and they talk about the testimony of Tracy Miner. So it sounds like Tracy Miner testified during one of these days. We just don't have video of it. Because maybe nobody wants you to know about this case. Hopefully the mainstream media is going to pick up on it and start televising it, because wouldn't that be nice? The first hearing we ever covered on this was only about 5 minutes long, and it was Judge Cannone. Magnolia Gypsy, thanks for your 5. Just some shadow ban money and gratitude for letting us join you in screaming into the same closet anytime. Jojo, LOL, love you, Melanie. Don't beat yourself up about pronouncing our towns incorrectly. It's not your fault that Joe Kennedy Sr. sold our R during Prohibition. That's very funny. Well, it's also Peabody, right? And there was another crazy one the other day that I can't remember right now. That was like wild. It'll come to me. Sandra, love your no-nonsense way of reporting these cases, but to be honest, what I love more is how you say Laura McLaughlin. Yeah, I think Laura McLaughlin is a lot more involved than people think. Because during the few times that she spoke out during the Karen Reed case, you could just say, and I'll never forget it. I'll never forget what it was. The first time we ever heard her speak, I think, was during that hearing in the Karen Reed case when the TUI document dump happened and the feds dumped 3,074 pages on both sides. And the defense attorneys got up, I can't remember who was speaking, and said, we haven't had a chance to look at it yet. It's 3,000 pages. We don't know what's in it. Yeah, Woburn. You guys, okay. It's spelled W-O-B-U-R-N. I said Woburn, and I was like, that's Woburn. No, it's Woburn. Thank you, Kathleen. Woburn. Laura McLaughlin said, I looked at everything. I've been through it all. 90% of it is the same stuff we already have. There's nothing exculpatory in there, right? All of the exculpatory stuff that the defense had in trial number 1 and trial number 2 came from the feds. The group text messages among the Alberts and the McCabe's telling the guy never went in the house. Yeah, I'm out here. I see them. They're out here, but they're at the Asian house. The 507 call from Jen McCabe to Nicole Albert. That was something like 38 seconds long or 22 seconds long or something. Long enough to have a conversation. All of the things exculpatory were in there. Right? So, eBay Warhol wants to know, were there any signal communications? They didn't bring up signal, but that's a good point. Thank you. Lala. Mel, Michael Easter has said on a podcast that you can actually speak to Google and they will tell you all of the searches and timestamps. He's former FBI, so I bet he could get that information, but I can't call Google and get that stuff. It would have to be FBI. So yes, thank you for that. Lala. Josh says, if Brian Walshe did commit this crime, the Home Depot visit afterward shows no intent to commit the crime. It could be evidence of a cover-up. You buy the tools of crime in cash beforehand, not afterward. Good point. Jojo says, "Jeez, this name haunts me in my dreams. I need to sage my house." Which name? Brian Walshe? Thanks, Jojo. Neo the One, are you saying that they can search a home when someone is missing, but not when a dead officer is on a front lawn? Mind-blowing. Yeah. Oh, yeah. Yes. Thank you for your 20 for pointing out that to us because, yeah. Thank you, Cindy from Virginia. Full downloads needed to get communications. Also, it could be that only comms were limited to date, but the rest was free game. Doesn't mean they're allowed to use it without consent. And here's where Proctor screwed up. I'm going to show you where Proctor screwed up, okay? Here's where he screwed up. Because it's all in writing. I'll show you. Hold tight, because I got to pull it up again because I have too many tabs open. Search warrant 34, which was to search the house. This is Proctor's probable cause affidavit. You have to show probable cause to a judge or a clerk or whoever's going to give you a search warrant to say, we have probable cause to search the house. Here's why. Here's what Proctor did. On January 8th, let me pull this up. On January 8th, Proctor goes to get a search warrant for the house at 516 Chief Justice Cushing Highway. Thank you, Cindy from Virginia. He checks off these boxes. This is a search warrant in the District Court of Quincy, because that's where the case was at the time. Proof by affidavit, which is hereby incorporated by reference, has been made this day, and I find that there is probable cause to believe that the property described below, and here's the boxes checked off, is intended for use or has been used as the means of committing a crime. 2, has been concealed to prevent a crime from being discovered. 3, is evidence of a crime or is evidence of criminal activity. It's to search the house. It's issued on January 8th of 2023 by John Looney, Looney, who I guess is the clerk, magistrate, or assistant clerk, because I don't think he's a judge there in Quincy. I just find you the probable cause affidavit. Signed by Proctor. Here's Proctor's probable cause affidavit. I, Michael Proctor, being duly sworn, depose and state that the following is true to the best of my knowledge. And this is to get a search warrant for the house. I, Trooper Michael Proctor, am a Massachusetts State Police officer and have been a police officer since 2013. I'm presently assigned to the State Police Detective Unit of Norfolk County District Attorney's Office, and I've been so since September of 2019. During that time, I've investigated and processed serious and violent crimes, including murder, suicide, sudden, suspicious, and unattended deaths, along with drug investigations. Through these investigations, I have participated in the execution of search warrants from which various types of evidence have been seized. I am trained in criminal investigation, including homicide, death investigations, crime scene investigation, collection of physical evidence, crime scene processing, and in the investigations of such cases. I have received specialized training to obtain and analyze cellular telephone data and call detail records in support of criminal investigations. I have a Bachelor of Arts degree in criminal justice from Anna Maria College. In addition to my assignment in the Division of Investigative Services, I've been assigned to the Division of Field Services, working in Troop C and Troop H. Based upon information contained in the numbered paragraphs below, which are the product of my own investigation and my discussions with the MSP troopers and detectives and officers with the Cohasset Police Department involved in the investigation, I submit that I have probable cause to believe that evidence of kidnapping and misleading a police investigation will be located at the house. And then they talk about some of the facts that we've already been over. Ana was reported to split her time between Massachusetts and DC, that Cohasset police responded to the house on January 4th because her boss called, he actually was the head of security at Tishman Speyer, called Cohasset PD because he didn't know where she was. And there's some confusion about whether Brian Walshe called this guy first and then this guy called Cohasset police. I'm not really sure. But it says Ana Walshe spends time with her husband in both DC and the 3 children in Cohasset. She hasn't been seen since December 30th. Further stated that her vehicle was present in DC. And then he goes on to state all of the other facts that we looked at before. And then he says, it should be noted Brian never contacted police regarding his wife, as he had only called her work, who in turn notified Cohasset police, right? So he called the guy who called the police because he said, last time I tried to do this around Thanksgiving and Christmas, she got mad at me. And she didn't want to get in trouble at her job because she was the breadwinner. They pinged her phone, and the phone pinged for the last time around Reservoir Road in Cohasset at 3:30 on January 4th. That's where they pinged it. But what Proctor does here, so I don't want to read this whole entire thing because my voice is getting tired. They looked through her financial records. They looked through for flights. They couldn't find any flights. They looked at Amtrak. They canvassed the area for video footage. They couldn't find anything showing her leaving. They didn't do that for, Karen Reed's case at all. They couldn't find any financial records after January 1st. They did the interview of the guy at the house, the friend at the house. I have a video of him we can look at. Then he talks about January 6th, how Tracy Miner provided written and verbal consent to turn over Brian's cell phone, 2 Apple iPads, and they were extracted. And then in his probable cause affidavit, oh, look, on January 7th, it says, Detective Schmidt, Trooper DeChico, and myself conducted an interview at 1:30 p.m. with Brian at his residence. Isn't that so funny how in all the papers, nobody mentions that Proctor was there on January 7th for that interview? Nobody mentions that. Proctor was there. They've already said they're not going to call him at trial in October. iPad, the nanny. Why it's turning yellow, I don't know. It does this every time I try and read it. He went to his mother's house, he said. He went to Whole Foods and CVS, but they went to Whole Foods and CVS because Trooper Kikowski reviewed the video at the Swampscott CVS. And he told them, I guess, also that he bought alcohol wipes and frozen foods. Frozen foods at Whole Foods and alcohol wipes at CVS. Trooper Kikowski reviewed the video at the CVS from 4:40 to 8:30 p.m. and he didn't find any video of Brian. And CVS did not have a record for a purchase of alcohol wipes for January 1st during that time frame. Kikowski traveled to the CVS in Salem and reviewed video from 4:30 to 8:30 on January 1. Brian doesn't appear to enter the store. The Salem CVS had no record of alcohol wipes on January 1st for that time frame. Sergeant Pantazelos, Sullivan, they all went to Swampscott Whole Foods and they didn't find Brian there. Then he said but here's the thing. So they go on, and then he puts in his affidavit of probable cause, Trooper Guarino and Trooper Keefe conducted a forensic review of the data extracted from the iPad mini that was given to Lieutenant Fanning by Brian. The review revealed all that his phone was unlocked on January 1st. The password was entered at these different times in the morning, 4 times. And then the review field revealed all of the Google searches on that date and time. And he puts all of the Google searches in the search warrant application showing probable cause, and therefore there's probable cause for us to search the house. However, it is found that those searches, the Google searches, were illegally obtained. All of that has to come out of the probable cause search warrant to search the house. And then whatever they found at the house needs to be excluded as well. And here's what they found at the house. The return of the search warrant shows what they found at the house, and here's what they found. In the basement, I think, 9 white hand towels, a utility knife, blue tape, black trash bag with red ties, a black Apple iPhone with charger. And this was all collected on January 8th. A red Apple iPhone with a green case, an iPad mini with a broken screen, iPad mini with black case with white child locks on the case, Apple MacBook, 3 of them, 4 receipts of purchases from various stores, blue notebook with dinosaurs on front and back, 1 opened roll of clear plastic tarp, 1 chef-style knife with brown handle and a silver blade, 1 chef-style knife with brown handle and silver blade, top of handle has clear duct tape wrapped around it, 3 bottles of hydrogen peroxide wipes, 4 bottles of hydrogen peroxide liquid, 1 bottle of hydrogen peroxide wipes, 1 Apple Watch wristband, 3 foot impressions were taken, 9 swabs from the basement floor, basement stairs, support beam in basement, knife located in kitchen cabinet. And they searched on the 8th and the 9th at 8 a.m. That is signed by Michael Proctor. Much of this has been impounded. Luckily, I had it already from a long time ago when I started digging into this case. Mardo wants to know, can the defense use Proctor's Brady violation in Reed for the Walshe case through his work on this case, which was the year prior? No. This case was a year after that case. It's never been determined to be an official real Brady violation. The judge has determined that there's never been a judgment that there was an actual Brady violation. He's been fired and all that can come in just like it came in the Karen Reed case, but it's a good question. Crazy Cat Lady, this is the first I've heard of this case, but if Proctor, Bukhenik, and others are involved, it's definitely problematic. Thank you for your super chat. Nina is here, and she says, how can the Google searches be done after they seized his phones? No, they were before. They were on New Year's Day. They seized his phones on the 6th and returned them on the 7th. And the searches sound too stupid, or am I wrong? They sound like Bukhenik. That's what people think. Except they did find blood in the basement, apparently. Hold on. Josh, yes, a download downloads everything on the device. The consent is what we agree can be looked at without a warrant. That's right, Josh. He's right. And I think plain view. It's a lame argument, but I don't practice criminal law in Massachusetts. Higgy is driving the ice cream truck, says there's going to be a lot of pro hoc VJ attorneys needed anywhere these clowns were involved in. Stevie Wonder could see through this. Thank you. Be a super chat. The caser says, I fully believe from what we're hearing that this guy absolutely did this, and I hope he doesn't walk because of the bad acts of the investigators. Just do better, MSP. How many people's constitutional rights can be violated? Can they just go back and say, well, he's clearly guilty, so, no big whoop. Doesn't matter. Jeannie Emerald, I'm so appreciative of you staying on the Commonwealth corruption case. Keep fighting the good fight. Free Turtle Boy, free FTB. Oh, the good ones are here, and they gifted a membership. Thank you. Film Freak gifted a membership too. Thank you as well. Leslie became a new member. Welcome. Charles Argo said, in plain sight, if you filter through 128,000 lines of data, and he can see that all the way from South Africa. So the world is watching. Nobody seems to care. Steve, writing style of the corpulent Ms. McLaughlin here. Nick says, check your email. Thanks, Nick. Okay, I can take care of that later. I have some of the stuff, but I can't stop what I'm doing right now to send you that stuff, but thank you. David, thanks for being with me for 13 months. PA, Pennsylvania pronounces towns weird as well. Lancaster is pronounced Lancaster. Yeah. Yeah, I don't know if it's regional accents or like what. I don't know. Jacob's proud Madre became a new member. Welcome. Maybe English isn't the Commonwealth's first language, says Leslie. That's true. Bob C says there's a conspiracy theory in this case. Ana was the real estate agent who rented those apartments in DC to spies that infiltrated the Secret Service. Well, I didn't know about that conspiracy theory. People have pointed out it could be like a Gone Girl type thing. Like maybe she just wanted to disappear and she was having an affair with this guy. I don't know. What they did find through his location data, was video of him at Home Depot buying some things and stuff that could be considered incriminating, and video of him at somewhere else buying some things that could be incriminating. And there's another 37-page filing. Or is this the one I just read? I don't know. I don't know anymore. But hang on. Let's look at the because I found this interesting. There's not, I mean, you can't find a whole hell of a lot on this case. Like the deep diving that I have to do and that I have people doing for me is like beyond deep diving. I do remember when it happened because I was following it in the news because I remember exactly when it happened, January of 2023. Thank you, Sandy B. It says, keep shining a light on corruption. Somebody's got to do it. Here's the friend that came over for dinner on New Year's Eve. And this is from CBS Boston. And this was, this aired January 9th of 2023. So it was after they searched the home.
WBZ exclusive. Just minutes ago, WBZ's Julie McDonald spoke with a man who celebrated New Year's Eve with the Walshes. He was one of the last people to see Ana Walshe before she disappeared. Julie joins us live in Boston now. Julie, what is this friend telling you tonight?
Well, Lisa, I've spoken with so many of Ana's friends since we first learned of her disappearance from police late last week. These are families along the South Shore, friends of hers in D.C., even former employees here in Boston in the hotel industry. It's been a roller coaster, emotional week for these people, desperate for information and really holding on to hope that she would return home safely this morning. Devastating news, those chilling details presented in court, and they all learned at the same time that we did. But late this afternoon, just now, I sat down to exclusively speak with one of Ana Walshe's very best friends. Now, Jem Mutlu is her former boss before she took this job in Washington, D.C., but he's so much more than that. This is a friend who was at the Walshe home on Saturday night and one of the very last people to see this Cohasset mother before she went missing. He's been in very frequent communication with investigators, meeting with state police, calling them multiple times since to provide any possible details that he can to help them as they search for his friend. But he described for me how everything seemed as it always was Saturday night, celebrating the new year together.
Brian had cooked an elaborate meal for us, and we hugged and celebrated and toasted and just what you do over New Year's, and there was a lot of looking forward to the new year. Like there was no indication of anything other than celebrating the new year, like problems on hold, whatever life's problems were. And life always gives us matters and problems and things to deal with, right? That just always is. But the fact that they hadn't, they had been living in separate homes. She was commuting back and forth. She wasn't seeing the children as often as she would have liked. I mean, she loved everybody. She definitely loved her children dearly. And So it was festive. She was texting with friends, and she was sitting next to me at the bar stool and at their kitchen. There was absolutely no indication that any modicum of a tragedy of disappearance or anything else could have happened that night.
Now, this dear family friend, Jem, he actually met Ana years ago through Brian. He was first friends and colleagues with Brian through a leadership course years ago, then met Ana and has closely befriended this couple over the years. Even that being said, his closeness and his love for this family, he admits that there were times during this week that he began to feel that this timeline didn't add up, and he sadly suspected foul play. You'll hear more from him ahead on WBZ at 6. I'm live in Boston tonight. Julie McDonald, WBZ News.
All right, Julie, we'll see you at 6 o'clock.
Tragic. I don't know. The volume on that wasn't that great for me, and it only came through one ear. I don't know if it was okay for you, but Michael says Walshe is 100% guilty. He dismembered his wife, and now he may be released to walk among us because of the MSP Clown Show. Right. Christy says, serious question. Why doesn't anyone ever mention the Albert's pool they filled in prior to selling? Because it was not Brian Albert's pool that was filled in. It was his brother Tim Albert's pool that was filled in. And so that has nothing to do with that. And so your serious question is, it wasn't Brian Albert's pool that was filled in. So there you go. It was his brother Tim's pool. And if they couldn't even get a warrant to go inside Brian Albert's house, you think they're going to get a warrant to look inside the Tim Albert's filled pool? Metal Chem, she's still alive. Everybody's crazy. I don't know. Well, do we trust the Boston Globe? I don't know. Sometimes they are inaccurate. Sometimes they're accurate. Here's an article from the Boston Globe, just to give us a little more background on this. This was just from June 26th of 2025. So here's an article that was reporting on these evidentiary hearings, because, at least one mainstream media thing was paying attention. One mainstream media. Cohasset man who allegedly K'd dismembered wife wants his Google searches tossed. Lawyers for Brian Walshe, the Cohasset man who allegedly did that to his wife. They're going to strike me again on this. Filed paperwork Thursday supporting the motion to suppress incriminating Google searches and other evidence from electronic devices that Walshe provided to state police at the start of the investigation. In a supplemental memo, Walshe's lawyers said he and his prior counsel, Tracy Miner, reached an agreement on January 6th of 2023, allowing authorities to conduct a limited search of Walshe's iPhone and his son's iPad. Walshe's consent was necessary at the time because state police hadn't obtained a warrant for the devices. In Thursday's filing, Walshe's lawyers said the agreement covered all communications between December 25th, 2022 and January 6th of 2023, the date the electronics were turned over. The sole exception was for communications between Walshe and his lawyer, the filing said. And then they go on to say Miner testified that the agreement did not include GPS location data or any browser or internet searches, the defense said. So I know that they submitted an affidavit from Tracy Miner with their papers, but the Boston Globe is reporting that she testified. So they often get it wrong, and I don't know if she testified in this hearing or not, because not all of it was televised. Walshe's current lawyers said investigators obtained the internet searches and GPS location data information in the same act of illegality, exceeding the scope of the consent. According to the memo, the state police began a forensic search of the devices on the night of January 6th, 2023, and continued into the early hours of January 7th. An investigator who conducted the work alerted colleagues on the evening of January 7th, it's Nick Guarino, they don't name him here, to the internet searches in question, which were later referenced in an affidavit for a search warrant, records show. Right, we looked at that search warrant affidavit. But before a warrant was issued, the filing said, police willingly and knowingly violated the agreement by exceeding the agreed upon scope by downloading and searching the entire content of Walshe's phone, his son's laptop, and a third laptop with a cracked screen that he turned over. The filing didn't detail the Google searches, but at Walshe's arraignment, a prosecutor noted some of the terms. We've seen them before. We don't need to see them again. In court, and that was during the hearing from June 18th, Walshe at one point shook his head during the recitation of the searches. Days before allegedly taking his wife's life, Walshe, who in 2021 pleaded guilty to scamming a Los Angeles art collector out of $80,000, had inquired online about divorce. Assistant Norfolk District Attorney Lynn Beland said at his arraignment. On December 27th, the defendant Googled, "What's the best state to divorce for a man?" Beland said. Rather than divorce, it's believed that Brian Walshe dismembered Ana Walshe and discarded her body. The additional searches were about, can you throw away the parts? What are the best ways to dispose of a body? What happens with ammonia? Best hacksaw, best tool to dismember, and can you be charged without a body? During Walsh's April 2023 arraignment on murder and other charges in Norfolk Superior Court, prosecutors disclosed that he was the sole beneficiary of a $2.7 million in life insurance that his wife had taken out. Walshe had been closely monitoring the Instagram page of a man he believed his wife was having an affair with, prosecutors said. This is what they said all of this at his arraignment, by the way, in April of 2023. When he lost touch with Ana Walshe for about 24 hours around Christmas of 2022, he and his mother hired a private investigator to follow her around Washington, D.C., where she had taken a new job with a real estate company, according to court documents. On New Year's Eve of 2022, the couple hosted Ana Walshe's former employer at their house. We just watched his interview, who left around 1:30 a.m. That was the last time someone had seen Ana Walshe alive outside of the defendant, Prosecutor Greg Connor said. The guest told investigators he had dinner with the couple and they shared champagne and wine, according to an affidavit. Brian and Ana Walshe were in a good mood and everyone enjoyed themselves, he said, adding that Ana Walshe appeared to be a bit tipsy from the alcohol while Brian Walshe appeared unimpaired. By 4:50 a.m., authorities allege Ana Walshe, 39, was dead and the disturbing Google searches started. Over the next several days, prosecutors allege Walshe cut apart his wife's body in the basement and discarded her clothes and other evidence in a dumpster at a liquor store near his mother's home in Swampscott. He also allegedly disposed of her remains in dumpsters at apartment complexes in Abington and Brockton. Police also allegedly found blood in the basement of the couple's home. But here's the thing. The reason that they were able to get to those dumpsters is from the location data on his phone that they initially got illegally. All they needed to do was get a freaking warrant. So if all of these searches of all of these dumpsters are thrown out because that's where they got it, it's going to be a problem. Seven days after Ana Walshe's disappearance, police searched the dumpster near the home of Brian Walshe's mother. Inside, they found a COVID vaccination card for Ana Walshe, an Hermes watch, and clothing Ana Walshe was known to wear, according to prosecutors. Forensic testing showed her DNA on items found in the dumpster, prosecutors say. The reason they got to the dumpster outside his mother's apartment is from the location data that they got from the phone that they illegally searched. But they're saying no big whoop, no biggie, because we would have gotten it eventually anyway. Walshe, 50 now, he's now 50, has pleaded not guilty to charges of first degree M, lying to investigators, and disinterring a body. Again, disinterring a body means digging it up. I don't know why everyone's getting this wrong. He remains held without, unless I'm getting it wrong. He remains held without bail and his trial is scheduled to begin in October. Yeah, October 20th, I think. July 24th is going to be the hearing on the motion to dismiss, which obviously I'm going to cover if it's broadcast or if we can get a Zoom link. But they find all this stuff in these dumpsters, but they got the location data from his phone illegally, in my opinion. We're going to have to see what the judge does with it, whether she throws it out. And that's what the Tinfoil Hat Society said. Well, if it's true, they have saw with her blood on it. The searches are only a small part of the evidence, right? But if the searches were obtained illegally and the location data was obtained illegally, do you see how that flows? That's fruit of the poisonous tree, right? Why can't they do anything right? Bev would have allowed it. Bev would have not even had an evidentiary hearing. Terry says the bone fragments on the hacksaw prove all those theories were wrong, in my opinion. Right, but how did they get to them? How did they get to them? Do we just allow constitutional rights to be violated because MSP is lazy? That's their argument. Josh says if Ana was the breadwinner, he wouldn't be concerned about what state was the best to divorce. She had the greater income. Right. That's true. He wasn't working. He was on house arrest. eBay Warhol says, actually, their son was the last one to see her alive. Oh, yeah, the 6-year-old, right? If we believe what he said. Right, exactly. So I don't know what to make of this. I don't know what a judge is going to do. Metal Chem 3R said, that's why our Constitution is here. These bad actors need accountability. Right. And Justin Rose says, I'm not saying he's innocent, but these same police officers planted evidence in the Karen Reed case. Yeah. Oh, and it gets better because in this case, Justin, they say that based on his location data, they know that 2 times when he went to his mother's apartment complex, that one of the times they could pinpoint that he was near the dumpster, and another time they could pinpoint that he was inside the apartment building. But remember, in John O'Keefe's case, they couldn't say that he was inside the house or on the lawn because, you know, there's a huge margin of error. Right? Why didn't they just get a warrant? Michael says if they toss the phone evidence, the state has no case. Everything started with the phone, right? The Google searches and the location data. Magnolia Gypsy says someone needs to teach the MSP that they just cannot do what they want. Right? There were some papers filed after the evidentiary hearing because they were allowed to supplement their filings. And here's the defense's supplemental memorandum, which we should take a look at because it's only 6 pages. And, you know, I mean, we're here, right? You guys got anywhere to be? You got time? Got time for one more? Filing number 104. Olivia! The disinterment of a body charge. Whoever willfully digs up, disinters, removes, or conveys away a human body or the remains thereof. Well, did he dig it up or remove it? I thought he just put it there. Removes or conveys away. Oh, so the conveying away. Okay, so it's the conveying away, right? Thank you. I thought they everyone was cutting and pasting it wrong and it should have said dismemberment and instead it was saying disinterment. According to WCVB, Brian Walshe was diagnosed as a sociopath, says Allie B. Yep. Minnie says, how can you trust phone evidence here and not in another case? How can they get things perfectly in one and not in the other? Because they've been doing it for decades, maybe, and they've always gotten away with it. Nobody's ever looked closely enough and nobody's ever exposed it. Right? Here's the defendant's supplemental memorandum after the hearing, and this was just filed on June 26th. Now here comes the defendant. This is the supplemental memorandum in support of defendant's motion to suppress the search warrants. Now here comes the defendant to respectfully request that this honorable court grant his motion to suppress any and all evidence obtained by MSP by way of search warrants, specifically warrants numbered 34 to 36, 39 to 46, and 76, and 119, footnote 2. Warrants 37, 85, and 136 did not yield any response or records, and the defendant withdraws his motion to suppress search warrant 188, Ana Walshe's iPad from Washington, D.C. This honorable court accepted evidence in the form of 25 exhibits and testimony from several witnesses over 3 dates. The defendant supplements his arguments in response to such evidence and pleadings by the Commonwealth, specifically to the Commonwealth's argument and this honorable court's question. We didn't hear the argument. The argument wasn't televised. If anybody but it can find any video footage of the Commonwealth argument in front of the judge, I would love to see it because we didn't get to see it because they don't want us to know about this case. Specifically to the Commonwealth's argument and honorable court's question whether any or all of the evidence is independent from the alleged police misconduct and or would have been inevitably discovered. So we know this judge from the little we've seen of her, and she does like to ask questions. And that she probably asked the defense, well, wouldn't they have inevitably found it anyway? Here's their response to that, or Larry Tipton's response. Relevant proposed findings. On January 6th of 2023, an agreement for a limited search of the defendant's iPhone and iPad attributed to the defendant's minor son, TW, was brokered between the Commonwealth and attorney Tracy Miner. And we live here now. We do live here now. The agreement was limited to all communications. Footnote 3 says, with the exception of attorney-client communication, from December 25th till January 6th, 2023. The date and time the devices were provided to law enforcement. Law enforcement. Who do I sound like? Law enforcement. The defendant consented to a limited search of these devices based on the agreement as he and his attorney believed and understood it to be, namely a limited search of only communications. When the state police responded to the defendant's home on January 6th, he also provided an additional cracked screen iPad. Testimony from members of the MSP indicated, quote, web-based communications can be found in the browser history. However, attorney Miner appeared to understand this as a reference to the JetBlue application's live chat feature. Attorney Miner testified, so she did testify. We didn't see her testimony at the hearing. Attorney Miner testified she understood the police would create a mirror image of the devices, but would and could, in her professional experience, limit their search to the agreement between her and ADA Lynn Beland, or Beland, solely to communications. Attorney Miner testified this agreement did not include GPS or location information or any browser or internet searches. The MSP began their forensic search of the devices above on January 6th and continued into the early morning hours of January 7th. The officer who performed the searches contacted his fellow officers via email, that's Guarino, on January 7th at 6:24 p.m. and informed them of the internet searches described in paragraph 18 in search warrant number 39. The police willingly and knowingly violated the agreement by exceeding the agreed upon scope by downloading and searching the entire contents of the three devices. Based on their illegal conduct, the police obtained the following information. Footnote 4, here's all the stuff they got. Search warrants 39 to 46 contain identical information in the supporting affidavit, right? Because we know they love to cut and paste. And here is what the defense attorney is saying. Based on their illegal conduct, the police obtained the following information. Number 1, the defendant's cell phone was manually unlocked at 4 different times when it was reported to be lost. Number 2, various internet searches labeled A through Q. Number 3, location data from the defendant's cell phone, which led to this stuff. A, video location data receipts from Home Depot on January 2nd, 2023 in Rockland, Mass. Number 4, location data from the defendant's cell phone, which led to B, video of a trip to Derby Street in Hingham on January 2nd, 2023 between 5:15 p.m. and 5:32 p.m. C, video and location data from the Claremont apartment complex on January 3rd, 2023. D, video location data from the Point apartment complex on January 3rd of 2023. And E, video and location data from the Chatham West apartments on January 3rd of 2023. F, video and location data from 330 Paradise Road on January 5th of 2023. G, video location data receipts from Home Goods and TJ Maxx on January 4th of 2023. H, video and location data receipts from Lowe's on January 1st of 2023. I, video location data and receipts from Home Goods on January 2nd of 2023. The defendant argues this information should be excised from all the warrants, causing them to be bereft of probable cause. Citing a case, Commonwealth v. Wad, 2 cases. The exclusionary rule bars the use of evidence derived from an unconstitutional search or seizure. The Commonwealth has suggested, and this honorable court has posited, that any evidence obtained as a result of the illegal police activity outlined above that led to the warrants would have been independently and or inevitably discovered. Lastly, the internet searches and GPS location data require separate and distinct probable cause determinations. Here's the argument. The defendant first turns his attention to search warrants 76 and 119. The defendant thanks the Commonwealth for clarifying the dates of service and processing and concedes these warrants do not fail solely or due to any delay under Massachusetts General Law 276. The defendant now turns his attention to the independent and inevitable discovery questions. The evidence outlined above did not come from any independent source. In order to be considered independent, the Commonwealth must establish the evidence was obtained wholly independent from any constitutional violation. Quote, the interests of society in deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime are properly balanced by putting the police in the same, not a worse position than they would have been in if no police error or misconduct had occurred. When the challenged evidence has an independent source, exclusion of such evidence would put the police in a worse position than they would have been in absent any error or violation. The Commonwealth bears the burden of showing by a preponderance of the evidence that the challenged evidence is admissible pursuant to the independent source exception. Pearson explains the Commonwealth must make two showings. Number one, the officer's decision to seek a search warrant was not prompted by the illegally obtained evidence. And two, the affidavit supporting the search warrant application contained sufficient information to establish probable cause apart from any illegality. The defendant's time is better spent discussing the second prong. Once the illegally obtained information is excised from the affidavit, there is not sufficient information for an issuing magistrate to determine that the items sought are related to criminal activity under investigation and that the items are reasonably expected to be in the place to be searched. The defendant respectfully directs this court to his memorandum in support of his motion to suppress the search warrants and oral arguments made on June 18th, 2025, with respect to a lack of probable cause once the illegally obtained evidence is excised. The defendant would be remiss not to question the confidence the Massachusetts State Police and the Commonwealth possess regarding their underlying understanding of the defendant's consent to search the devices if they proceeded with search warrant applications based largely on the material already illegally obtained. The defendant reiterates his argument that probable cause to search one device does not automatically support the seizure and search of any and all other devices in the family home. Any argument that the devices are linked in iCloud is made without any specific factual basis of knowledge. Further, the police never applied for a search warrant to Apple for such iCloud information. The discovery of the evidence was not inevitable. In sum, the Commonwealth must establish by a preponderance of the evidence that the discovery of the evidence, namely the internet searches and the GPS location data, would have been discovered by lawful means was, quote, certain as a practical matter or, quote, virtually certain. The court must take into consideration any bad faith of the police, namely conducting an unlawful search in order to accelerate discovery of evidence. Do you think it's bad faith? Will the judge think it's bad faith? Specifically, the severity of the constitutional violation is critical in deciding whether to admit the evidence if it is shown to be inevitably discovered. Further, the consideration of inevitability is made on the circumstances existing at the time of the unlawful seizure, namely the illegal search of the devices on January 6th and into the 7th. The police obtained the internet searches and GPS data and location information in the same act of illegality, exceeding the scope of the consent. Neither can be said to have been obtained first to support probable cause for the other. The police obtained arguably inculpatory GPS location data and video from January 1, 2023 to January 6 of 2023. This evidence was solely discovered by the illegal search of the defendant's cell phone and would not have been discovered as a practical matter by any lawful means. The SJC has also made it very clear that the inevitable discovery rule has no application where a warrant should have been obtained but wasn't. Lastly, Massachusetts does not have a good faith exception to the exclusionary rule. Moving on to the son's iPad. If the court concludes that the police had probable cause for a limited search of the son's iPad in order to obtain a possible, quote, timeline, because it was reported that Ana Walshe fixed it early in the morning of the 6th, that does not bootstrap probable cause for GPS and location data from the defendant's cell phone for 6 days or a search of the browser on the child's iPad. The police could have performed a limited search of the child's iPad for the times it was activated or manipulated on the morning of the 6th, as opposed to a full-blown search of the device. Without such state and federal constitutional safeguard, police could engage in overly broad general searches of people's property when they may only have probable cause to search a limited portion of the defendant's property. For the foregoing reasons, the defendant requests this honorable court allow his motions to suppress and find that none of the evidence in question was discovered independently or was inevitable by lawful means. What say you? Tina says, I'm so confused. I thought they searched the house on the initial visit. They did. He allowed them to look around and look at the Volvo, but then they came back with a warrant, and that's when they started finding the stuff in the basement, because I guess maybe they didn't search the basement. I don't know. Josh says, so the Commonwealth is arguing if Brian Walshe refused, they could have gotten a warrant. Where was that at 34 Fairview? Right. It wasn't. They did get subpoenas for Uber and Lyft, and they couldn't find any Ubers and Lyfts. Carol says, wow, these troopers really screwed up. Michael says, we would have found it anyway. That's what they're saying. Yeah, inevitable discovery. We would have found it legally eventually, but we didn't. We didn't get a warrant because, we just didn't feel like it. Because, we just do what we want all the time, and nobody's ever called us down on it. And were it not for the Karen Reed case, calling attention to Trooper Proctor's misdeeds, they still might not have known about it, right? Because remember, they made earlier motions to get all of Proctor's communications, and knows what they have there. It's wild, isn't it? So the next thing that's going to happen is on July 24th, we're going to have a motion to dismiss hearing. All of the motion to dismiss documents have been impounded, so we can't get a hold of any of them. Most of this stuff has been impounded too because nobody wants us knowing about it. Which, is a par for the course. I mean, why couldn't you have gotten a warrant by saying he lied to us that he went to CVS and Whole Foods? So therefore we need to know where he was, so we need his location data. But they didn't. But is this judge going to buy it? I don't know. Apparently she was questioning them during the hearing that we didn't get to see because, shadow banning. Thank you, Karen. Karen says, I'm not crazy. Thank you for being a light. On Venmo, Betsy says, my Lord, you keep me sane. I don't know. Sometimes I feel like I'm going insane too. It's wild. And here we are. They've never been held accountable, says Olivia. Tinfoil Hat Society says the MSP needs to get rid of Bukhenik and Tully, among others. Tammy says reverse reconstruction. No, it's well known, but not from the Massachusetts population. And Monj, so sorry if you've already covered my question. Can the defense file for a mistrial if the fruit of the poisonous tree is proven? Well, the case is not on trial yet. These are all pre-trial motions. So this was just an evidentiary hearing on the motion to suppress. And so there's no trial going on. So there's no need to file for a mistrial yet. But I could see how you'd be confused because Judge Cannone never held any evidentiary hearings. So, you see people testifying and you think it's a trial, but it's not. Terry said, what if Walshe had deleted the Google searches in the interim? They wouldn't have inevitably found it. But according to some people, you can find deleted searches, right? And according to them, they did a whole entire extraction and then they looked at all of it, even though they shouldn't have looked at all of it. They could have just waited until they had a search warrant to look at all of it, but We know they didn't wait for the search warrant to look at all of it because Proctor talks about the Google searches in like a lot of his search warrant applications to go search other things. So it seems pretty clear. It seems pretty clear. Wait, I am so confused. Wait, what is this? KBD, infuriating, proper protocol, proper procedure. This could have been prevented if MSP did their job correctly. Thank you, Tammy. Thank you for thanking me for covering it. The son called them to look in the basement. Yeah, he did testify. Bukhenik did testify. If you didn't watch the hearing yet, go back to the last 2 streams that I did on this. That the son gave him his artwork and then he ran over to the basement door and then the grandmother grabbed him as if he wanted him to look in the basement or something. He did testify to that, right? Somebody said something like LTL did a stream today with a hearing in front of Judge Cannone. What? What are you talking about? There was no hearing today or yesterday even. So I don't know what you guys are talking about. I don't know. Patty says MSP screwed up in the Reed and Birchmore cases and now the Walshe case. God knows how many other cases they're involved in. Right. Yeah, she was originally assigned to this case. I have no idea what there was a hearing today with Judge Cannone. I must have been old because she's not on the case anymore. And there hasn't been a hearing since June 18th. I mean, I looked at mass courts 5 minutes ago. So I don't know. I did see that he posted something about new charges against Brian Walshe, and I'm thinking, like, what are you talking? There's no new charges against Brian Walshe because I'm on this. I have all the documents, and so I don't know what that was. He posted an old hearing, but it was new to his channel. Okay, KBD. So I don't know what that was, but the title made me think that there were new charges against Brian Walshe, and I was like, did I miss something? Did something happen like yesterday or the day before? So I don't want to spread any misinformation. So, I don't know. She will have to, well, Heather, that's a great question. Will she have to rule on this motion, all these motions to suppress before the upcoming hearing? Well, the upcoming hearing is going to be on the motion to dismiss because everything's impounded. Will they even televise it? We'll have to get a Zoom link for that. She's going to have to rule on the motion to suppress before the trial, but she's not going to have to rule on it necessarily before the motion to dismiss, unless the motion to dismiss hinges on her decision in this case, which I don't know, because we can't get a hold of the papers. We can't get a hold of the papers. I don't know. Penelope says, I just got a call from our circuit clerk's office to report for jury duty on Tuesday. It'll be my first time. Oh, great. Awesome. That's great. Do your civic duty. It's very important. It is very, very, very important. Oh, yeah. We're going to cover lots of other cases while this case is waiting for kickoff. I have Lindsay Clancy to start with you. Lindsay Clancy is another Massachusetts case, very, very tragic one. Mother that took the life of her 3 very, very young children and then jumped off the balcony while her husband was at the store picking up food. And Kevin Reddington is defending her, and he's claiming postpartum psychosis, and the husband is standing behind her. And a lot of people have written to me who are friends with Lindsay Clancy who are like, listen, you don't understand. Like, this is really like psychosis. Like, they put her on some crazy medication and she loved her children. So I don't really know what to make of it yet. But we got to do that. You come in here. You come in here. Yeah, Lindsay Clancy is horrible. What else do you want to do in the meantime? Because, Koberger is no longer. He pleaded guilty to everything and said that he did it. So that's not going to happen, that trial in August. I'm always open to suggestions. If you'd like to send me suggestions in the show, in the comments to that video. It's very sad. It's very sad, the Lindsay Clancy case. Have you seen the video clip of AJ in the basement at 34 Fairview? Very interesting. Yeah, you know, Charles, that is a very old clip. That's been around for a very long time. It just seems to be resurfacing now. But I know it's old because in the first trial, they had video footage coming out of the bulkhead and out into the front lawn. And that's that camera guy who was there with them. And so I know that it's been out there for a while. Thanks for your super chat. But I mean, you guys can correct me, but I'm pretty sure that video has been out for a while of AJ pointing out like the plywood on the basement floor because the new owners, I guess, let them in. Yes. We already started looking into the case in California that Alan Jackson is on. I had already been looking into that case prior because I have driven that stretch of the PCH in Malibu a million times. It's called like Dead Man's Curve right by Pepperdine. It's a tragic case. And you know, I need to look into it more before I can speak intelligently about it, but I had been looking into it because of the fact that I've driven by that area so many times. And Alan Jackson has just been hired as the defense attorney for the defendant, who's like 20 years old at the time, right? Yeah, I know the video of Alan Jackson being filmed going in the basement in the garage at 34 Fairview, old address. Yes, the new owners let him in, right? The new owners let him in, but I know that I've seen that video like before now at some point, and I can't remember where. It's back in focus. Got it. Back in focus. He is on the case. Give me 1 second. Frazier Bohm, I think he was like 20 years old at the time, and he was driving allegedly over 100 miles an hour around on the PCH, and he hit a bunch of parked cars and then killed 4 sorority girls students from Pepperdine that were on the corner. And it's tragic. It's tragic. But Alan Jackson apparently has just been hired to represent him in this case, and I need documents. I need all kinds of things on that. All I have is, you know, news articles, and he's been charged with 4 counts of murder, among other things. And it's a tragic, horrifying case. And he's a wealthy kid, and he was driving a BMW, and there's a lot of issues. Happened in October of 2023. Oh, he was 22 years old at the time. 1, 2, 3, 4 counts of murder, 4 counts of vehicular manslaughter with gross negligence. He's out on $4 million bail. Horrible case. Horrible case. Yeah, there's plenty of Massachusetts case. Ashley says I was reading that the 100 miles an hour might not be correct. There was also, I remember when the story first happened, so I'm getting some details wrong. Give me some grace for a second. But there were some allegations of some guy chasing him with road rage. I don't know. No alcohol or drugs in his system. I can't do stuff in Stearns, Christine. I can't do it. I can't do it. I cannot do it. I physically makes me ill. I just can't do it. So many people have gained so many subscribers and their channels have blown up for covering it. I just can't. It's so against my moral code. Everything about that case and Madeline Soto revolts me to the point that I in no way could cover that case in any way that would not rip the soul out of my body and destroy me forever. There's just no way. I can't. If you guys can stomach it, good luck. I can't do it. It's revolting. Absolutely revolting. KKB says the accident reconstructionist says 70 miles an hour. Black box says over 100. It's going to be interesting. And of course, you know, Alan Jackson is always interesting. He may be hired just to, did they overcharge with murder? I don't know. I got to dig into it more. I just don't know. Thank you. Yeah, we have about 3 or 4 prior videos on this. And so the playlist is in the show notes below. So please catch up if you haven't yet. I know I just can't. So many other people are covering it that I can't do. Praise be. Praise be, MJ Spidey. Praise be. Especially I have daughter. Like, no, I just can't. And Jenna, same thing. It was the same thing with Koberger for me. I just I have, college age kids. Like, that's just, I couldn't. Too much. And like you guys, got to take care of yourselves too. If you got to dip out because you can't handle the subject matter, dip out. I try and handle it as respectfully as I can. But some of this stuff is just too much for me. And the reason that I got into Walshe is because of these allegations of the same troopers testifying in the case and being like, oh, they're up to their same old shenanigans because nobody's ever going to call them out on it. And somebody needs to. Hopefully this judge is not going to allow it. I know. Everyone has their boundaries and we can respect them. All right. Well, thanks you guys for coming and hanging out with me for over 3 hours today. I hope that you enjoyed the topic. I hope that I think we're pretty much kind of caught up on this case unless anything else breaks, like we get a hold of any more documents. I think we're kind of caught up on it. Unless you have any specific questions, you can let me know. We can start trying to cover some other things in the meantime. Any new information on Rex Heuermann? Yes, I saw something yesterday pop on my feed that his wife is auctioning off his 1972 Jeep for money, to make some money. But as far as a trial date or anything else, I haven't heard anything about that yet. But it's local for me, and that's a case that is very close to me because we've been having body parts wash up here on Long Island since my kids were little, and those are the beaches that we went to, and it's a personal one for me, thinking, oh, we're at the beach. Are legs going to wash up today? And also pisses me off because they had a description of Rex Heuermann in 2010 that was buried in a file because the last person to see one of the victims alive said there was a man who came to the house. He was like 6'6", 6'7". He looked like a giant ogre, and he was driving a green first-generation Chevy Avalanche. And that information was buried in a file because the chief of police, James Burke, and District Attorney Tom Spoda had their own shenanigans going on, and those two eventually went to jail. But they just didn't want people looking into their stuff. So there you go. Everybody stay safe this weekend. I'm sure you'll see me around. Make sure you have a subscribe button hit. Make sure you have all notifications set because you never know what's going to happen. You never know what we're going to do next. Thank you to the moderators for keeping it classy today. You guys are amazing. The weather is beautiful here. I'm going to go touch some grass and get some sun. And I hope that you all do the same and you're having great weather where you are. So in the meantime, thank you, moderators. I love you with all of my heart. If I don't see you soon, I'm going to die. Law and Crime Trials is a Brian Walshe hearing from 6 months ago. Not sure what it is about. It's only 5 minutes long. I think it's the one that I covered in one of my first trials, in one of my first streams. And so, thank you, eBay Warhol, but that's where I got, what they did was they put it all in one video and they condensed it into separate videos. Then there's a hearing of Judge Cannone that we did that was 5 minutes long. And I think another hearing that we did. So check my playlist and make sure we already didn't do it. Thank you for your super chat, Judge Beverly the phony. It's true, Mel. Walshe went up on new charges in front of Cannone this morning. LTL played it. No, it's an old video, honey. It's an old video. I'm sorry, Adam Handful, but it's old. It's an old video. Judge Cannone is no longer assigned to this case. She is no longer assigned. She was taken off this case many, 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 many months ago. So I don't want to spread misinformation. And I haven't watched this video, but there's been no new charges. I have the docket in front of me. And it just didn't happen. The last court appearance was on June 18th. So let's keep it to what we know. Do a deeper dive on older cases of Proctor and others. Yeah, but if there's no papers and there's no, thank you, Munch, if there's no papers and there's no hearings, then we can't get a hold of the stuff and things that we need. So unless you can point me to a specific case with video and wait, what? I'll look for it. Just read that the Stearns case had the same illegal phone search issues and the judge is allowing the data to be used. Interesting. Well, that's not, what state is that in? That's not Massachusetts. I've tried to stay away from that case so much that I don't even know what state it's in. Where's this? Florida, right? I think it's Florida. If anybody comes across any new video, actually new video from Brian Walshe, send it to me. My email's in the show notes. Cannot respond to all of your emails, but I do read them. I get like 1,000 a day. So I can't be your pen pal or anything either, or go get your kid and bring your kid to South America, even if you promise me 10 acres of land. I can't do that either. I can't imagine the crazy emails that I get. All right. Stay cool, stay kind, stay classy. I love you guys. I love the mods. Have a safe and fun 4th of July weekend. And make sure you have your notifications set, because you never know what I'm going to do next or when it's going to be until we set a regular schedule when we get past the holiday weekend. All right, everybody. Peace out, my friends. I love you.